Good morning. Happy Tuesday. It's July 5th. I'm a little under the weather, but we've got coffee. We've got Cursey words. We've got time together, and that's what matters most. Let me know where you're coming in from. I'm going to let you know what's on the show today so that if you're in the beloved replay crew, I see you. We love you. The timestamps will be down below after this stream so that you can get to the shit that you're looking for. And with that, today we've got a few quick bits, and then we're going through this new motion to set aside from Team Heard. I'm sure some of you have already dove into this already. I know everyone has covered it, but generally, even when that happens, I see a lot of you saying, but Emily, you haven't covered it. So we're talking about it. This is a first look for me. I have seen only headlines. I have not seen any coverage. Honestly, I have been resting for most of the last few days, just because I'm a little run down, which happens. So with that, we are going to talk about this motion to set aside, a quick Jen Shah update, some copyright, intellectual property, quick bits, and then into that so that we have plenty of time for questions and for catching up. We all just need a chat. So with that, we're going to get into it. My kids showed me something this weekend that was a little bit of good news, which after, shootings going on over 4th of July, we could use a little bit of good news because everything else feels like fucking bad news. That's why. So let's just roll it and get into it and start with a little bit of good news.
Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the Cursey words. This channel is where the law nerds unite to talk about facts, not fuckery.
And yes, before we jump into it, I know there are a bunch of new Britney motions. I am going to have to figure out how we're going to deal with all of them. I think they're just going to get their own stream. We need a Britney stream. There are so many new motions, and I said this when Britney's conservatorship ended. A couple asked, are you going to keep covering this? I'm like, of course we're going to keep covering this. It's not done yet. And some of y'all were like, but she's out of the conservatorship. Yep, but it's so not done yet. It's so not done yet. So we are going to be covering all of the motions. I think we just need a Britney only live stream with no other topic because it's so many things. So as we get into it and I get to say hello to you, where you are coming in from, I have like 9 bottles. If you guys follow me on Instagram, you will see in my stories that I have all of the water today, but all of the cats. Like the paw nerds are on the desk, the water's on the desk. I feel like I am like in my little corner here. I think the timer, if it is not, or the counter, if it's not stuck, is about to bing. From what I saw on the front end of the channel, which is great. We're on the road to, I don't know where we're on the road to. We're at 656. So we're on the road to 675. It feels like the proper increment to be like, we're on the road. Choo-choo, road to 700. I don't even know what's happening. So with that, a little bit of good news. My kiddos this weekend, and I've seen this now reported, I didn't do a ton of the social media newsy things this weekend. Honestly, just needed some rest. But this SD, I'm sorry for your loss. It is just grief compounds, but hopefully you will have time to celebrate a long life well lived, and that takes time to get to. It takes time to get to the celebrating a long life well lived, but hopefully you will be able to get there in your grief. It is always shocking and difficult. And speaking of grief, we have had lots of conversations over at my house about Technoblade's passing and his family announcing that passing. I thought it was done with tremendous empathy and honor to his community. And my kids logged into Minecraft this weekend, and Minecraft has changed the pig on their launcher to Technoblade's avatar. And I thought it was so incredibly, touching and kind of just what a beautiful honor to have a game that, obviously Technoblade is a Minecraft creator. If you aren't familiar with Technoblade, he's a creator that passed away from cancer at 23. His family shared that information with his audience. Audience including not just myself, but my children and lots of your children as well. A lot of you have said how much techno has meant to you and to your kids. But I was just really encouraged. You know, I know that when you're dealing with large companies that maybe you're not going to see something like that, but I was really, really encouraged to see, and I'm trying to pull up a photo of it and I'm doing it very badly, but I was really encouraged to see so quickly that they honored his avatar in the game because, oh gosh, Emily, can you talk without getting choked up? No, I can't, but I always intend to. I don't know why I can hear myself. Sorry. I can hear myself from somewhere. Is it on my phone? Probably. But when, you know, my kids are like, well, Technoblade never dies, which is something that comes up within his content, they have that now in the game, right? And so that is when you're talking about grief with kids, and you're talking about grief with anyone, but especially when you're talking about grief with people who are new to grief. Unfortunately, I am not new to grief, but it feels like a Band-Aid ripped off every single time. But when you're talking about grief with kids, ways to still connect are so important. And this is a way that kids can still connect, that they are reminded that through the game and through the content, that really that memory is alive. And so when we talk about the good news, I love seeing that honor in the game. And I hope they update it so that when, if you rename a pig Technoblade, maybe it will get its own crown too. I just think it is really, truly an incredible thing. And yeah, I just love that. And I love seeing the game honor a creator that loved the game, but it's also a way for people to process grief. And I don't know if Mojang thought about that, but it is a way that keeps someone alive in not just their content, but in their game, and makes people feel connected, which is something that in grief can be hard to do, and something that in grief with kids can be hard to still feel connected to what's been lost. Darn it. I am crying again. But I think that's not what I wanted to do. Oh, that went to the tweet. I've been meaning to go and share this, but I think it's just really an incredible way to honor it. So Minecraft has honored several popular players who have passed away within the game. I've seen that. And I think it really is just an incredible thing. And my kids were just so encouraged. Like, they were thrilled when they went and logged into Minecraft and saw that. So, and my youngest is like, Technoblade never dies. I'm like, yes. So this has been a good way for us to talk about grief, and to talk about how you still are connected to people and how we are all still connected. My emotional support cat is just going to cover me in cat hair. That's what's happening? Sure. Okay. We're just going to be covered in cat hair. That's what's happening today. So I really think that that's an incredible thing. And I loved seeing it. I really just loved seeing it. So Rebecca said, thank you for sharing about Technoblade. I had no idea. But this opened up a conversation with my teenage son, who was a huge fan. Oh, Rebecca, you're welcome. It's very hard. It's a hard thing to parse. I'm sorry. I don't want to make everyone cry in the morning. I am definitely trying not to. I know we are a hugely empathetic audience. My pawnerd Fred, we have code Fredded into my office, but I just thought, oh God, I thought I'd be able to talk about the good news without getting choked up, because I thought I would be able to, but also just not able to. I just thought it was such a beautiful thing. And it, when we get to where are the silver linings and things, I think this is one of them. And I really thought it was a beautiful thing. And I love seeing that. And I love I love, again, touching on the impact creators have and the positive impact positive communities can have, because the positive communities are what we really look for. And there can be so much negativity online, and there can be so much just ugliness online, but there are wonderful corners of the internet that are connected with community, and that is always what I focus on. So even when I take steps away from being online, it's because I just need a moment. But it's never a moment from y'all, because I love the Law Nerd community. It's a moment from like all of the other stuff going on in the world that sometimes can feel too much. And when there is so much, and in the last few weeks, it's been so much, and then we'll move on to today's topics. But in the last few weeks, it's been so much. It's okay. And this, I see people struggle with this a lot. It's okay to say, I need to take a step back, and just breathe and connect with my family before I jump back into it. It's okay to protect your mental health and take a step back before re-engaging and take a breath. Letting grief and the news and life kind of absolutely take you to the point where you've got nothing left to give doesn't help. And being able to reset, to continue moving forward is fair, and it's totally fair. So with that, we're going to move on to our topics today, but it's just, hi, darling. We can't even drink coffee. Okay. Yeah. Fred is just like, we're here today. So with that, it's totally fair to give yourself the space and the grace that you need. And it's hard with news, and I'm here to give you guys grace and space. It's hard when it feels like there's a lot going on to the world to feel like it's your obligation or responsibility to stay dialed into all of that. It's okay to occasionally say, I need to opt out for myself. And I just want to remind you that that's okay. And that's why we are talking about, it's time to talk about other stuff. We're going to be talking about pop culture stuff today, and a ridiculous motion that, I'm probably going to make fun of. Let's just be perfectly honest. That's what we're going to do. So let us get to our quick bits. We have a quick bit about something I'd never even heard of, and I want to know if you'd heard of it. So we'll put up a poll in a minute, because I want to know if any of you have heard of it. And real quick, we're going to go to Jen Shah. So let me just let Miguelina know what the poll will be when we get to this story in our chat, because I'm curious if you've heard of this. I haven't. So Miguelina, we'll do this after Jen Shah. We'll put up a poll about that. All right, let us get into quick bits. It's time. It's Tuesday. I've already been emo. I've already told y'all I'm a little under the weather, so that makes it worse. But I'm tired from travel, truly. And we've got a lot coming up this month. There's no time to be tired right now. So let us get to quick bits. It's time. Quick bits. I keep covering up my coffee. I have a new coffee mug too that I have to try, but it's tall and I worry that I'll knock it over. But first quick bit. Jen Shah has her final pretrial conference this afternoon before trial. So now is the time. We will see. Today, hopefully we will see if we are going to trial. By we, I mean like us as observers, and Jen Shah and her lawyers as, participants. But we will see if this is going to trial on July 18th. And it will be very, very interesting to see if it does. So today's the final pretrial conference. There are some pretrial motions that are pending, and the pretrial motions that are pending are regarding expert witnesses and things. So we also need to do a catch up on what's going on, because things are amping up between now and July 18th. Things will be ramping up in the Jen Shah trial, and we will we will absolutely need to see what's going on. So for those of you in the chat asking who is Jen Shah, I just jumped right into it, didn't I? For all of the law nerds who found me during the Johnny Depp and Amber Heard case, Jen Shah is a Real Housewife of Salt Lake City that is going to trial in the Southern District. Excuse me, coffee. In the Southern District of New York. She is alleged to have committed conspiracy to commit, well, she's alleged to have conspired to commit wire fraud and alleged to have conspired to money launder. This was a case with 11 defendants. All of them have pled guilty except for Jen Shah. So she will be the lone defendant at trial. It seems that there will be testimony from her former right-hand man, from her assistant Stu Chains, Stuart Smith. It seems that we will get testimony from him because he's pled and he had a modified plea deal. So we will see what happens. Man, oh man, oh man. So this will be the first housewife criminal trial that we get because Teresa and Joe Giudice both pled guilty. So those were negotiated plea deals. But with Jen Shah, it will be, do you want to just come say hi to, not the microphone. Please don't bump the microphone. Please don't bump the microphone. With Jen Shah, it will be a criminal trial. So that's going to be very interesting. It is the scheme that the government is alleging is a very complex telemarketing scheme. We will see how that goes when there is just one defendant sitting there because they have the empty chair ability to say, hey, we can, blame these other people who aren't sitting there. Okay. So it seems like she's actually going to trial. I don't think she's going to plea. If she was going to plea, I don't think she would have spent the money to get this far in litigation, but anything can happen. Anything can happen. And that's the thing. Anything can happen. So, yeah. So anyway, I'm definitely not plugging Real Housewives of Salt Lake City. That's where Jen's from. I mean, people are like, how do I know who Jen Shah is? None of us would know who Jen Shah is really if it weren't for Real Housewives of Salt Lake City. She's from the show. Bravo doesn't need me to plug their shows. They seem to be doing fine. Unless it's Orange County. Orange County's ratings didn't seem that good last time. They really didn't. All right, let's move on. We've got a story that is a wild trademark case that I didn't know was a thing. This is coming to us from Law 360. It's one of those quirky things that I'm now going to want to follow. So this will be our poll, but have y'all heard of the Museum of Selfies? And Tech's going to put up a poll so you can vote in the poll so I can see. But have y'all heard of Museum of Selfies? Apparently there's not just a Museum of Selfies, but there's also like a selfie museum and others. Like, what is up with the Museum of Selfies and the Selfie Museum? So in Florida, there is an ongoing trademark dispute between Selfie Museum and Miami Selfie and Museum of Selfies. So, Selfie Museum, Miami Selfie, and Museum of Selfies. There's one in LA, there's one in Seattle, there's one in Vegas, but I don't know if it's the Selfie Museum or Museum of Selfies. So on Friday, a federal judge let the managers of Selfie Museum and Miami Selfie off the hook for claims that they infringed on Museum of Selfies trademark with copycat art exhibitions, but refused to dismiss the claims against the corporate defendants. So the corporations are still on the hook, but the individuals are not. So U.S. District Judge Beth Bloom said that Museum of Selfies, Inc. had cured defects in the initial complaint, which she found to be a shotgun pleading, like all the things, and allowed its claims against Selfie Museum, LLC, and Miami Selfie to proceed. So it seems like Museum of Selfies, Inc. is the one trying to protect the trademark. The judge declined to allow Museum of Selfies to again amend its allegations against the defendants. So this has gotten to a dismissal, like, hey, you've had a chance to amend, you've tried to fix it, and you can't fix it. So yes, there is one in Vegas. The one in Vegas is part of the bigger group. But I think the one in Vegas is part of the Museum of Selfies. That's the like OG one. Because Museum of Selfies seems like the OG one. And there's one in Hollywood, there's one in Vegas, but that's the Museum of Selfies that's suing over the trademark. So it looks like a place to go and take cool selfies. But yes, there's one in Los Angeles, there's one in Vegas. How much are tickets? Oh, I want to know. $25 for tickets. Are walk-ins welcome? Walk-ins are welcome. Let's see, what else? This is their press. Good. Let's see if there are gallery. Nope, that's not a gallery. About, I see no other photos at all. So it looks like a place with really cool themed rooms where you can go take selfies. Let's see. There's one in Vegas too. But there's also a selfie world in Vegas. So there is a Museum of Selfies in Vegas and a selfie world in Vegas. So it's a room where you can go and do stuff like this, I guess. This is the Museum of Selfies at the link. So I guess you can just go take selfies in cool places. So there's a bunch of them if you're interested in going to take selfies. But the trademarks. I don't see how it's a museum. I don't think it's a portrait gallery. I think it's interactive rooms where you go and take selfies. The judge declined to allow Museum of Selfies to again amend the allegations. So we got to the point where it's like, yes, you win, but no, you can't amend. So now you're going to have to go with what you've got. Judge Bloom said that to properly allege trademark infringement claims under the Lanham Act against individual defendants, the plaintiff must show the defendants actively and knowingly caused the infringement. It sounds like they just worked for the corporate entities based on this. The statements alleging active and knowing involvement by the individuals are all conclusory, according to Judge Bloom. So that got yeeted. Quote, other than alleging that the individual defendants are officers or members of the corporate defendants, plaintiff provides no factual allegation that the individual defendants actively and knowingly participated in the infringement activities, as opposed to other members or employees of the corporate defendants. Thus, while the allegations suffice to assert a claim against corporate defendants without more, the allegations do not satisfy the pleading requirements for individual liability. So a motion to dismiss happened. And with the motion to dismiss, they yeeted the individuals, but not the corporate entities. So both businesses operate interactive exhibits featuring backdrops and props patrons are invited to use to take interesting photos of themselves. What? Wonderful. In its Soup Museum of Selfies, which was founded in April 2018, claims that Miami Selfie and Selfie Museum intentionally copied the Museum of Selfies trademark in art exhibitions in Denver, Seattle, Miami, Raleigh, North Carolina, Atlanta, Austin. I'm so confused as to why some of these just say city names and some of them say city and state. Denver, Seattle, Miami, Raleigh, North Carolina, Atlanta, Austin, Texas, San Antonio, and Alpharetta, Georgia. I think I pronounced that right. If I didn't pronounce Alpharetta right, I apologize. Isn't it near Atlanta? I don't know Georgia well. There is one of my favorite sushi places in Atlanta, though, and I am tempted to drive my butt the 3 hours to Atlanta to go get sushi. Yes, I am. I'm tempted because we didn't get to do it last time I was in LA because we were so busy with family stuff. Museum of Selfies claims Selfie Museum knew about the mark since at least October when Selfie Museum filed a request to extend the time to oppose the mark's registration. So they engaged in the trademark registration and they were like, yeah, we know. Selfie Museum filed notice to oppose the mark on January 12th, arguing the mark has not acquired distinctiveness and is merely descriptive of plaintiff services, which is a fair contention. Selfie Museum did not open to the public until well over a year after Museum of Selfies opened its first location in 2018. According to the complaint, Selfie Museum also filed trademark applications for the marks Selfie Museum and Original Selfie Museum. Selfies. Let's see. Museum of Selfies is represented by Reiner and Reiner. And then I lost the rest of it. They're represented by lawyers. So, if you're interested in going to a museum wherein you can take selfies, someone has a donut wall. Oh, I visited the Seattle Selfie Museum, then an actual museum. This is not an actual museum. This is kitschy places to take selfies. It seems like somewhere that content creators would be like, I think there are probably plenty of videos of, I spent a day at. It seems like it would be great. Oh, I saw a fantastic comment. Danny S. It is in fact Selfie's choice. So there we go. For those of you who took the poll, let's go ahead and end the poll and see and go from there. But Alfreda is pronounced Alpharetta. Okay, well, then I've slaughtered it completely. I've slaughtered it completely. Apologies. So let us move on. This is a case that's moving on to the Supreme Court. I need to do a deep dive. I do need to do a deep dive. Let's see. Have you heard of Museum of Selfies? No, 90%. Yes, 9%, with over 6,000 of you voting. There we go. If you're looking for somewhere to go and take selfies, though, like I could see Museum of Selfie coming in super handy if you have like a tween want to be influencer who really wants to go take selfies. I could see this being like a great birthday party for like 12-year-olds. Because it would be really fun. Like I could see this being a fun event. I could see getting drinks with friends and going to do that. I can see that happening. I have got to text Dr. B. It is so hot in here right now. I'm like, where is my air conditioning gone? Why is it not turned on? Normally it's kind of chilly in my office, but this morning I'm like, I need one of Peter Mon's fans this morning, and I do not have one. So let's see. You guys are like, yes, I can see that. I can see it being a birthday party location. Like I could see it. Dallas has a fun one called Rainbow Vomit. Getting drunk and then going to a selfie museum. Like I can see that being a good time. Like don't threaten me with a good time. I could sing that being fun. Do they serve drinks? I have no idea. I would love to just curate the selfie backgrounds. I mean, that looks like it would be fun. Girls' birthday ages 12 to 15. I could see it being a fun tween birthday for sure. Hen nights. Oh, that would be fun. Ozzy, Annie, the point is that it's totally cringe. That's the point. The point is that it's cringe. A friend of mine and I went to Candytopia when it was coming through LA, and it was hilarious. Like we had the most fun just laughing because it was hilarious. So Seattle says no food or drink. Of course they say no food or drink. They don't want you to get the stuff on the stuff. So the stuff on the stuff. Emily, could you be more specific? No, not today. So let's see. June 10th. This is a little bit late. We've been meaning to cover this. We need to do a full deep dive. I just haven't had deep dive needed. Just haven't had time. Justices told cramped Warhol copyright ruling hurts artists. The Warhol debate is going to the Supreme Court. They did their oral arguments, and this is over. I'm going to jump into the article. Also, we need a little bit of backstory. There is a copyright fight going on with the Andy Warhol Foundation and a photographer who took a photo of Prince that was then changed. I guess that's the entire point of the case. That was then used as inspo and or ripped off to create a Warhol painting of music legend Prince. The court heard argument about whether this is transformative work or not. This is actually a really substantial case in the world of trademark law, or not trademark law, copyright law, and whether or not transformative work is just changing the medium of something, changing the photo of something. So there are other cases. I'm trying to pull up the photos. Emily, are you prepared? Always. We're more prepared for our later ones. I'm just trying to find the two images to show them. Okay, perfect. Thank you, NBC News, for having the two images side by side. Let's see. So the Supreme Court is taking up this dispute. This is the photo from the original photographer. This is the Warhol. So whether or not this is transformative enough, and we will talk about this in context too. We've been meaning to talk about the Kat Von D case with regard to transforming a photograph into a tattoo, whether that's transformative enough to be transformative work. So with this, it is a replica of the photo, but is it transformed by just by painting it, by changing the color? What does transformed even mean? I mean, when you look at the two, are they different to you? Are they not different to you? So the court is going to have to struggle with what is transformation, what is not transformation, and what's transformative use. It's been a while based on my memory. And again, I am not a Supreme Court watcher. I do not follow everything they do super closely, but in memory, it's been a while since they've taken up a copyright case of significance to try to define these things. So in March, the court decided to take up the appeal, and they had oral argument in June, which means I think we'll probably get a ruling next term. So the argument is, if adopted by this court, the Second Circuit's approach to transformative use would work a sea change in the art world and to copyright law more generally, overturning decades of settled expectations and chilling core First Amendment expression, the Warhol Foundation wrote. This would have enormous practical consequences. And when we say foundation, we mean Warhol. The foundation said, among other things, artworks displayed in museums that were based on existing works could be imperiled, and future artists could be deterred from building off older works to offer new creative messages if their works were not protected and cannot be displayed or sold. Attorney Martinez of Latham and Watkins an attorney for the Warhol Foundation told Law 360 in an email Friday that the present case gives the High Court an opportunity to reaffirm its commitment to free artistic expression. Within copyright law, the fair use doctrine plays an essential role in safeguarding the First Amendment, Martinez wrote. Andy Warhol's transformative work of art are fully protected by law, and we look forward to the justices considering the case this coming fall. So I think we will see this case being determined in the fall. But we will see. Transformative use is part of fair use. If you want an Emily breakdown of fair use, I have a video on this channel going over the Ethan Klein, Matt Haas case, and that court works through fair use. Here's what I tell all creators, because creators ask me all the time, and I talk about it when I talk with vidIQ and other creators on creator channels talking about creator education. And you guys know how much I love YouTube and love creators. So when we talk about it, they're like, okay, but what is transformative? Is this enough? Is that enough? And here's the thing. It depends on the judge. And that's the difficult thing with relying on fair use as a defense. It depends on the judge that's hearing the case. So if you want to see how the judge walked through it in the Haas Klein case, the judge did a great job in walking through the different considerations. That video is a great breakdown of fair use, but it depends on the court. So when they're looking at fair use, is it transformative is part of what the courts are looking at. There's 4 prongs. So to have the court start looking through these determinations again, could change fair use. And that very much matters, not just to traditional artists, but in the digital age. What is transformative? What is fair use? And what are the guiding principles, and how will the court decide this? I'm very interested to see. I'm very interested to see how this will be done. So that. Let's see. So they're saying the Second Circuit decided that this was not transformative, and that's why this is going up to the Supreme Court so they can take a look at it again. We'll see what they do, but it has the potential to change our understanding of fair use, which again matters very much for content creators of all kinds, and not just traditional artists. Because when you talk about, me now repeating myself, when you talk about digital use and things like court coverage, when are those things transformative? When are they not? And where are the boundaries? And that's what we will see. So I'm very interested in this case. We need to do a history of this Warhol case. I haven't had a chance to do it yet. It will be a podcast episode, because then I can do it more linearly without repeating myself, which is what I try to do in the podcast. Do you still end up repeating yourself, Emily? Yes, I'm ADHD. It is one of the quirks. It is one of the quirks that I work on. Worse when I'm tired and not feeling well. So I will do kind of a linear walkthrough of how this case even ended up to a point where the Second Circuit made a decision, to the point where it's now before the Supreme Court, because I think that'll be helpful ahead of the Supreme Court deciding. But covering the copyright laws is something I'm very interested in, because it affects so many of us, and it affects us on this platform so much, and everyone. So, all right, I have cat glitter. It is time to move on. Those are our quick bits. We were doing 2 quick bits because this Depp Heard motion is long. That's why we did short, quick bits, because it's long. Because it's long. Is this live? Yes, we are live. It should say premiere up at the top when they are premieres, so that you guys know the difference between it being a live and a premiere. The premieres are the podcast episodes. So as a point of reference, the title should say either TES or The Emily Show when I'm premiering a video with live chat, and then you'll see me in the live chat under this channel. And that's me in the live chat. So, let's see. There was one more question. Prince's estate is not involved in this case at all. Todd, yes, I didn't realize that needed to be clarified. No, this is between, and I think I said it at the top, the case is between the estate of Andy Warhol and the photographer, not Prince. So Prince's estate is not involved. This is the photographer. And, no, I think I texted my husband. I think my husband forgot to change. I think he forgot to change the settings on the air conditioning, because we were gone. So when we're gone, we tend to set the daytime temp to a bit higher, because we're gone. Like, comfortable for the cats, but maybe not as cool as I would like it to be under my lights when I'm streaming. So I just think he needed to change it back to a normal temperature, so I would have air. I need air. Air me out, please. I need it. That's not what I meant, but you know what I meant. Cool me off. I'm a woman of a certain age. I do not want to be hot. And I have hot coffee, which I normally don't do in the summer, but I do for y'all. Next Tuesday, I'm making cold coffee. I'm doing cold brew. Almost Empty Nester. Would NFTs be a part of this? NFTs are going to be a very big part of this growing conversation, because are NFTs transformative? Are they not? Who has the rights to them? Who has the copyrights to them? Copyright law, look, for any of you interested in law, if you have a background in tech, this reference made me live. So thank you. There are some in the chat who will get it. There are some in the chat who won't get it. But I see you. Oh, I still haven't put up my... it's here. I keep forgetting to put my switch back where it belongs. But it makes it easier for you to see my TARDIS. Anyway, what was I saying? NFTs. So who owns the rights to shit is going to become much more interesting. So if you have a background in tech and are interested in law, or you're interested in law and you don't have a background in tech, a tech background will help. And with that tech background, getting into intellectual property is a growing field. Like when we talk about growing fields in law, I absolutely see kind of a PR media marketing side of law, because lawyers, y'all watched it happen in Depp v. Heard. You watched the lawyers that understood or didn't understand tech. We even saw some of it in Rittenhouse. We are going to continue to see it. Digital evidence, understanding if evidence has been manipulated or moved, just understanding that the kilobits or bytes or megabits or megapints are the same or different in certain things. All of that is going to matter. And it's something that older attorneys probably have not kept up with unless they are heavily tech inclined, which is unusual in the lawyer space. A lot of lawyers don't want to answer their email, and they don't do like literally a law firm is somewhere where you hear, I don't do email. Like I have someone who does that for me. So tech, PR, media, understanding social media is going to be a growing area in law, either as a lawyer or as a consultant who works with law firms in the digital discovery realm. If that's what you love to do, you don't necessarily have to go to law school to do that. You can still work legally adjacent. And intellectual property and copyright, all of this is going to continue to grow as an area of law for those who are inclined and have a tech background. MB said, that is my lawyer. The amount of lawyers who would come into my office, I am not tech brilliant. I am tech knowledgeable, who would come in and be like, I can't figure out my email. Have you opened the email program? What program? It's just always it's just always there. What do you mean it's just always there? And then you find out that people never close their programs on their computer, and it's just always there. It's like, no, you just open your email program. There's a program. Oh God. Oh God. So I can't imagine what it must have been like to be our tech support for the county, dealing with these phone calls of, I need this one program. I don't remember what it's called, but it's always there. I can't imagine how challenging that would be. I can't imagine. I just can't imagine. All right. KIU, aka Christine, I have a tech background but don't understand American law. See, here's the thing. The lawyers understand the law. They need the people to understand the tech. And it is I see it as a hugely growing industry. I really, really do. So I'm going to say hello to a few super chats, and then we're switching topics just because we have a minute. Fanny Wiggles. Thank you for the giggle. Just wanted to say thank you. You've inspired me to quit my retail career and become a full-time content creator. Absolutely do it. Absolutely do it. Let us know in the chat the kind of content you are creating so everyone can support you. I worked my fair share in retail. I think it's why I understand humanity the way that I do. Look, I think everybody needs to work with the public at some point. It's the only way to actually understand people. Amanda said, just discovered you. You're amazing. Well, thank you. I will always take the compliments. I'm a creator. I love positive feedback. I love being acknowledged. It's great. JBM, hello from Tallahassee, working and drinking Diet Cherry Dr. Pepper. Cherry Dr. Pepper is good. I generally, most of the sweeteners in diet tend to give me headaches, unfortunately. So I have to either decide to go like full sugar or fizzy water, which is always kind of a bummer. Think the law nerds can make a motion to set aside a lane. Motion granted. No, we can't set aside a lane. We need the humor. We need it. Roboto Studios, can Amber and her lawyer get in trouble with the judge? Oh, I'm going to come back to this when I get to questions after this motion. Question, will you be looking at the new suit against Timberlake about making of the 2020 Experience documentary film that never got released? I hadn't even heard of that. I'm going to save this one so I can make a note. I'm fascinated. I didn't know about that. Hello to Durham. Emily, where do you buy the YouTube sub counter? It's in my Amazon shop. So there will be a link to my Amazon shop, and it does a bunch of different things. I use it for a sub counter, but you can use it for a sub counter on Instagram or Twitter too. You can use it for weather and incoming calls. Like, it has so much functionality, but right now I think it froze. Like, we broke it a couple times during this last trial. It might have gotten disconnected. We had a power glitch, so it wouldn't surprise me if this glitched. Let's see. It's great. It's the metric timer. So if you go to my Amazon store, oh yeah, it disconnected. If you go to my Amazon store, you will see it there. And then I get a small percentage of you buying stuff that you would buy anyway. And that's always helpful. So that's where that is. Hansel, thank you for the group hug. We all needed it. We did. Minecraft has honored several popular creator players. My oldest was telling me about that. So thank you. Thank you for making this real, raw, and beautiful. I always get nervous about being, well, I don't have great, when I am talking about something that I am feeling, it's very difficult to regulate, which has always been. It just is. It just is. I'm getting better at just letting it be without apologizing for it. Both my ADHD twins love Minecraft. There's so much to do. They were also super excited about the Live Forever of Technoblade. I know, it's just such a beautiful thing. It's just such a beautiful thing. My little cousin who lives with us was in tears, and it really makes me sad to see him so sad. I ordered him a Technoblade plush, and I don't think I've ever seen him so excited. We ordered some merch for our kids as well. More for my youngest, who's more connected that way. For my oldest, it's more of a conversation about what is life, what is death, what is this one life we live, what is spirit and soul and spirituality and, God and universe and the force, and what does it all mean? They are deeper, more contemplative conversations with my very introspective 14-year-old. The original hymn said, "Good morning. I'm curious, where did you buy your YouTube sub counter? I'm a baby YouTube channel and would like to get one." Good. We've addressed that twice now this morning, and mine got disconnected from my Wi-Fi, so I'm going to try to reconnect it. The thing I love, I don't think I can do this while I'm live. I don't think it will work. The thing I love is that I connected it to my lights, and that's why the lights also flash when it bings. So it's due for a bing, but I'm going to have to connect this later. I'm going to have to disconnect and reconnect, which I cannot do while I'm live because I need to get into the stuff. Oh, lolly go lightly. GG. Peg R, my condolences. I never knew him, but I understand grieving. I lost my husband and father within a few months of each other. I can't imagine. Grief is a measure of the love we share. Thank you for discussing. It is so needed. Grief is very hard for me to discuss. It's also hard for me to process, but I've talked about it in the past. And there's just been so much loss in the last few years. And so every new thing just builds, doesn't it? Grief feels impossible. Yep. It does sometimes. It does. First super chat ever. Thank you, Awkward Aquarian. Found you through Adam McIntyre and stayed because your stream feels safe for me with my ADHD, PTSD. Thank you for all you do. You are an inspiration. You're welcome. We make this chat a safe space unless you show up being a dick, and then we eat you. It's a safe space for people who are welcoming and compassionate, and law nerds. Welcoming, compassionate law nerds are always welcome. And there are so many of us in this stream that are not just ADHD, but lots and lots who are touched by PTSD and CPTSD, and amongst our other various traumas. And that's why we keep this chat a safe space, because so many of us bring so much into it and are so healed by being with others, and myself included. So thank you. Humanoid, good to see you. Give your sons a big hug. Cancer is a big old bitch. Yep. And needs to flip off. Yep. My stepdad was taken too soon by liver cancer. Much love to your family. Thank you. I think it was particularly hard that we were coming in. Also, this happened like as we were coming back from my father-in-law's funeral. So there will always be grief, but it's compounded by other recent grief. The selfie thing sounds like a Monty Python skit. Will there be a killer rabbit? There better be, with big, sharp, pointy teeth. It's a photog studio where you are your own photographer. I mean, really, yes. It kind of reminds me of the photography challenges in Animal Crossing. Like, that's what the Museum of Selfies reminds me of. Question, how do trademark works? Oh, I'm going to do that when we get to when we get to questions for sure. From Georgia near the I-75 between Chattanooga and Atlanta. Swing by, I'll go with. We'll do a law nerd meetup and go get sushi. It'll be great. Welcome, Cecile. You can always be an official law nerd. You don't have to be a member, but I appreciate the support. Your insights are amazing. Your sidebars are amazing. You're amazing. Well, thank you, thank you, thank you. Should we get into this fuckery? Should we just lean into the fuckery? Let's lean into the fuckery. Let's lean in. Let's lean in. Let's lean into the fuckery. All right, let's do it. Back to Johnny Depp and Amber Heard. Johnny Depp and Amber Heard. The verdict is in. The case is not done, and that's the way it's going to be for a while. This motion comes to us from Elaine C. Bredehoft, defendant and counterclaimant Amber Heard's post-trial motions filed July 1st. Ooh, baby. I should note, post-trial motions aren't unusual. These are kind of the precursors to an appeal. This is a first look from me. I'm sure this is not a first look for all of you. I'm sure some of you have already covered or watched other creators cover that, but this is a first look for me. So let's get into it. Post-trial motions. All right, we're going to go to the table of contents and see what we're in for. The damages awarded by the jury are unsupported by the evidence and the law. Cool. The verdicts on the complaint and counterclaim are inconsistent and therefore should be set aside. Ooh, I can't wait to talk about this. Love talking about this. You guys, if it's your first time going through this, just pop a 1 in the chat. Let's see. The First Amendment bars recovery for defamation by implication when the statements at issue are true on their face. Girl. Objection, fuckery. We'll get there. The jury's finding of defamation by implication with respect to the op-ed headline statement is contrary to the law and unsupported by the facts. Look at all of you are like, oh, it's our first time. I love that y'all are like, we're just waiting for Emily to cover it. Great, great, great. Thank you. I see you. I see all of you. All right, we're all in this together. Fantastic. Mr. Depp did not present evidence of actual malice. Mr. Depp did not present sufficient evidence to support a finding of defamation by innuendo. The court should conduct an investigation of juror number 15 and whether jury service was proper and due process was protected. Oh, good. We're going to get to due process today too. Fantastic. Fantastic. Oh, Rebecca, this does not bode well for us if Runkle was cursing. The thing is, we watched the trial. All right, look, they got to try it. We're going to enter this with, they got to try it. It's their job. But, all right, table, good. There's cases cited. Great. We love case law. We love code. Defendant, we're just going to go with AH and JD as best we can. So I'm not repeating their names over and over and over. AH respectfully moves this court to set aside the jury's verdict on all 3 counts of plaintiff and counterclaimant's JD's complaint, dismiss the complaint. We don't want to just set aside the verdict. We want to dismiss the entire complaint. Look. The amount of opportunities they have had to set aside the complaint have been substantial and vast. The different ways they have tried to set aside this complaint have not just been the original motion to strike, original demur, the motion that the UK case should be controlling and therefore this case can't even come to court. I know I'm missing some. And then at the end of evidence, a motion to strike at that point, which we saw argued by mostly Rottenborn and Ben Chu during trial. And now we are getting to another, don't just set aside the jury's verdict, but also set aside the complaint. Y'all tried that already. Y'all tried that already. Y'all tried that already. So they want the jury verdict yeeted. Yeet the jury verdict. No jury verdict. The jury verdict sucks. Get rid of it. They want to yeet the entire complaint, dismiss the complaint, and alternatively order a new trial. Can you imagine doing this again for 6 weeks? Can you imagine doing this again for 6 weeks? Alternatively, order a new trial and investigate potential improper juror service, which truly is what I'm most interested in. But it's the last one, so we're going to have to get through the rest of it. In support, AH relies on the prior record, including objections and arguments during hearings and at trial, motions to strike, and the arguments following. Yeah, you've already made all of those. Summary of the argument. Open mind. We're going to have an open mind. I can't do another trial. Y'all are like, good for content. No, I can't do this again. We have other trials. Who pays for this if it's a redo? The parties pay for it if it's a redo. But look, I haven't looked at their arguments yet. I have looked at literally nothing. If the juror issue in the Maxwell case did not rise to the level of a new trial, that will tell you how high the bar is. That juror misstated things on their juror questionnaire of substantial significance. I was surprised that a new trial was not granted in that case. Joe Neerman was like, nah, the bar is too high. And I'm like, but if we're going to get near the bar for a new trial, this is it. This is the circumstance that's it. This isn't going to be it. What it's not going to be is it. From the beginning, let's get into reading voice, shall we? We're going to do a dramatic reading. From the beginning, Mr. Depp set out to try this case as a domestic relations dispute he wished he had tried rather than settled in 2016. Mr. Depp's counsel argued through the trial that the issues before the jury began 6 years ago when Ms. Heard obtained a domestic violence temporary restraining order against Mr. Depp on May 27, 2016. Mr. Depp and his legal team told the jury they were seeking to restore Mr. Depp's reputation and his legacy for his children. And this was the first time Mr. Depp had been able to tell his story since Ms. Heard obtained the DVTRO in 2016. The claims in this case were far different than the case Mr. Depp tried to the jury. What? Wait, I'm lost. I got lost in my reading voice. What's happening? The claims in this case were far different than the case Mr. Depp tried to the jury. Wait, what? What? Okay. This is why this is the only topic today. We're going to be here a minute. Mr. Depp's claims arose from the op-ed published by the Washington Post on December 18th, 2018, 2.5 years later. Mr. Depp alleged that 3 statements, one, the title authored by the Washington Post. He didn't allege it was authored by the Washington Post, but go off. One, the title authored by the Washington Post formed. This sentence sucks. Mr. Depp alleged that 3 statements, one, the title authored by the Washington Post, formed the basis of his defamation claims. He didn't allege that. They did. That's not alleged. That just is. Okay, I can't argue with every sentence or we're never going to get through this. 3 statements formed the basis of his defamation claims. One of those statements was the title, but it was republication. This is oversimplifying. Okay. To avoid explaining to the jury the UK final judgment, Mr. Depp finding Mr. Depp to have committed 12 acts of domestic violence, including sexual violence, Defendant Exhibit 133, Mr. Depp represented to the court that he would limit his damages claims to the period of December 18th, 2018 through November 2nd, 2020, the date of the UK judgment. Yet Mr. Depp made no such effort at any point in the trial to so limit his claimed damages. They talked about the limitations on damages. The facts were different than the limitation on damages. They talked about the limitations on damages. And so did her side. Both sides talked about the limit on damages from December 18th, 2018 to November 2nd, 2020. Yet Mr. Depp made no such effort at any point in the trial to so limit his claimed damages. Instead, throughout even the closings, you should have objected, Mr. Depp continued to urge the jury to restore his reputation and legacy to his children as a result of Ms. Heard accusing Mr. Depp in May 2016 of domestic violence and obtaining a DVTRO. That characterizes things in an interesting way. In a very interesting way. Here's the thing, though. That wasn't about damages. That was asking them to find liability. When they got to arguing damages in closing, what they argued in closing was Mr. Depp's worried about his name, not about the damages. It's not about the money. It's about restoring his reputation. And the only way they could really argue that is if you're arguing defamation by implication in this case, it's got to go all the way back to where it started. And the reason it goes back to where it started is because of Amber Heard. Amber Heard wrote in the op-ed 2 years ago, I became the face of domestic abuse. The 2 years ago statement is one of the statements that was found to be defamatory here. But you can't try that being defamatory to a jury without talking about what happened 2 years ago to give context for why that statement has a defamatory meaning without going back 2 years to say 2 years ago this happened. That's why there's a defamatory implication in this statement, because it's defamation by implication. We're in for it, y'all. Buckle up. Fred came back. Fred was like, what's happening? What's happening? The jury's verdict was obviously influenced by Mr. Depp's pleas in the face of the court's preclusion of Ms. Heard from introducing evidence that Mr. Depp had already, in fact, been adjudicated in the court of his choosing to have committed not just one act of domestic abuse, all that was needed in this case for a defense verdict, but 12 acts of domestic violence. We've changed from abuse to violence, but okay, including sexual violence. We've gone over the court's ruling about the UK case. CEG that video. We covered it. Last week's Emily show. We'll link it down. We'll link it in the description. Last week's Emily show covered the court's ruling about why it didn't come in. Or why it wasn't preclusive. Not all of why it didn't come in, but why it wasn't preclusive to this case. The exclusion of the UK judgment, coupled with Mr. Depp's continuous urging to the jury to go back 6 years and exonerate him and restore his reputation, resulted in an indefensible $10 million compensatory damage verdict and a $5 million punitive damage verdict. The verdict is excessive as a matter of law in light of the evidence in law and should be set aside. Not if the jury believes he lost pirates. Because it's less than what he was shown with regard to pirates. Further evidencing the confusion resulting from Mr. Depp's efforts to relitigate the 2016 domestic relations matter. Is it domestic relations, or is it domestic abuse, or is it domestic violence? This is me being picky. Emily, are you being picky? Yes. If you're calling a thing within a legal motion, words matter. Call the thing the thing. Like, what is it? Call the thing the thing. And call the thing the same. Ugh. Further evidencing the confusion resulting from Mr. Depp's efforts to relitigate the 2016 domestic relations matter without the truth of the UK judgment. The ruling? Without the ruling of the UK judgment. Without the ruling of the UK judgment. Okay, but it's your truth. Fine. The jury's dueling verdicts are inconsistent and irreconcilable. Disagree. The finding of defamation against Ms. Heard with a $2 million award is inconsistent with the finding of defamation against Mr. Depp with a $15 million award. Disagree. In the face of these inconsistent verdicts, the judgment should be set aside and a new trial ordered. OFFS. Can you imagine? Can you imagine doing this again? Retrials are just a mess. You know why retrials are a mess? This is why this retrial would be such a mess. Because it would be like, but in the UK, you said this, flip, 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 flip. The amount of flipping of binders that would happen, because it would be here's the UK case statement. Here's the statements from depositions. Here's the statement from the previous trial. You now have multiple deposition statements from the main parties, trial statements from the main parties, and UK case statements from the main parties. You now have so many statements that it's going to be just a nonstop, like, but you said this here and you said this here. Oh my God, that would be such a fucking mess. At trial, Mr. Depp proceeded solely on a defamation by implication theory. Yes. Abandoning any claims that misheard statements were actually false. No. Saying that they left a false implication because the statements were vague. Legal writing is advocacy. Legal writing is advocacy. They are advocating for their client. I am just annoyed. This is them advocating for their client. That is their job, even when it annoys me because it flies in the face of what we've seen. But whereas here, A, the statements were true on their face, which Mr. Depp never challenged. B, the plaintiff is a public figure, which Mr. Depp has conceded he is. And C, the subject matter of the op-ed is on matters of public concern, which this court earlier determined as a matter of law. The First Amendment prohibits claims by implication. No, that's not the right conclusion. So they're trying to argue that you can never have a celebrity case of defamation by implication. Interesting. I wonder if that's what they're going to appeal on. Well, this appears to be a case of first impression in Virginia, meaning this has not been decided in Virginia. That might be a appealable point that let the appeals court decide it. And the appeals court might actually have a valid and overriding interest in deciding it if it is truly a matter of first impression. Here's why I say if it is truly a matter of first impression, because when I was going through the court's ruling of the UK matter for the podcast last week, the court pointed out specifically that Bredehoft had said the court had never denied a matter of comedy, which was, I believe it was comedy was the issue, which was giving deference to foreign jurisdictions and rulings. And the court said that's simply not true. So the court has already put on the record that what Ms. Bredehoft represented in motions was flatly not true. So when I read something like this is a matter of first impression in Virginia, I also now, after reading the court's ruling saying, no, Ms. Bredehoft, you are misrepresenting things in your motion, that's not the case, I am now reticent to believe that things are as they are being represented. And that's where my hesitancy comes in. So while this appears to be a case of first impression in Virginia, dicta in our courts and holdings in other courts in similar circumstances warrant applying this doctrine to this case. What doctrine? Which doctrine are you referring to? The First Amendment? Is that what For fuck's sake, what doctrine? Which doctrine? If it's dicta, it's not. Dicta means it's not binding. Dicta means it's shit that's said. It's not binding precedent. It's like, ugh. If it's dicta, it's not a doctrine that's going to be upheld, Elaine. That's not how case law works. I'm going to lose my mind before the end of this live stream. I am going to lose my ever-loving mind before the end of this live stream. Hold on. We need to put dicta in the longer dictionary. Hold on. We're going to the books. I'm going to lose my mind. I'm going to lose my mind. I'm going to lose my mind. But we need to define dicta for the Law and Order Dictionary without me just making dick jokes. So, because that would be more helpful. And it's been a long time since I've been in law school because I'm old. So let's get to dicta. Should be pretty close to the top here. Let's see. Oh, they've got all different. There's a lot of different kinds of dictum. All right, we're going with the easy one. Dicta. Where is it? A statement of opinion or belief considered authoritative because of the dignity of the person making it. A familiar rule, a maxim. C.e.g. dicta. Well, a statement of opinion or belief considered authoritative. It's a statement of belief, but it is not binding. So, it's like my opinion is where we've gotten with dicta. We're going back to Tamara Judge. Someone insert the meme here. It's like my opinion. It's like my opinion. So, dicta of the courts. But if this really is a matter of first impression, meaning the Virginia courts have not really decided whether or not a defamation by implication case can happen with a public figure, is very interesting. Like, it's very interesting. Sally, thank you. I'm breathing. I'm breathing. What is that book called? Oh, this is Black's Law Dictionary. I want an updated one, but this is mine from law school, so it has my notes in it, which I love. This is the 7th edition. But I actually need an updated one. And I should get an updated one, but again, I get tickled when I go through my Black's Law Dictionary and see my notes from law school, and then I think to myself, sweet, sweet summer child. But I think there's also a digital version. I just like going to the book. It's much more dramatic. Okay. Let us get back into, I'm stuck on the fact that this might be an issue of first impression, which I'm actually really interested in, if it is. Mr. Depp never challenged the fact that Ms. Heard did not write the title of the op-ed. No, because it's a republication, for fuck's sake. One of the 3 defamatory statements comprising Depp's defamation claims. Instead, Depp contended that Heard's tweet of a link to the article the following day constituted actionable republication, and the jury agreed. In addition to establishing dangerous precedent suggesting anyone tweeting or retweeting, it wasn't a retweet. Let's pound our fists in rage together. Was it a retweet? No. Why was it not a retweet? Because she added more. Did the court rule on this specifically? Yes. What did the court rule specifically? All together now, the court ruled that just retweeting a link is not republication. Just retweeting a link is not republication. But quote tweeting an article and adding more is republication. This was not a retweet. This was a quote tweet. In addition to establishing dangerous precedent, suggesting anyone tweeting or retweeting an article, the court literally, I'm still not done yet. The court literally fucking said that tweeting or retweeting an article or link is not republication. The court literally said that this is not precedent. The court literally said that this is not actionable. So this entire argument is just grumpy. Just no. Just no. Just no. Alley Cat, I will come back to this in questions because I know I mentioned it a little. Oh, I'm trying to star this and it won't let me. Hold on. I will come back to this in questions about the first impression because I know I talked about it. I might have gone fast through it, but I will come back to the issue of first impression. It means, well, no, I'll just do it now. The courts haven't decided it enough. Y'all are warning me not to get too mad. We're on page 12 of 53. We're so fucked. We're going to be here forever. IT Mac Pro, I use retweeting and quote tweeting synonymously. Exactly. The court literally held that this is not what happened because nothing in Ms. Heard's tweet constituted a legally enforceable republication. False. This count should be dismissed. False. Since the damages award does not separate out the three separate statements, nor were they asked to, in the event the court does not dismiss all three counts, the judgment should be set aside and a new trial ordered on the remaining counts. No. For the jury to find Ms. Heard demonstrated actual malice, Mr. Depp was required to establish that at the time the op-ed was published, Ms. Heard did not believe she had been abused or that she had doubts about whether she was abused. But Mr. Depp presented no evidence that Ms. Heard did not believe she was abused. Instead, the evidence overwhelmingly supported Ms. Heard. Ms. Heard believed she was the victim of abuse at the hands of Mr. Depp. They're allowed to determine that that is not a genuinely held belief. We know she believed it. She wrote the article. They're finding it was not a reasonable belief. Are we going to have to go back to the jury instructions on, hold on. We need to talk about actual malice real quick. This is why I should preview these things. But no, I think the first reaction's better. I think you getting to see me parse this in real time is probably more helpful. But we need the definition of actual malice stat. Let's pull it up real quick. Let's see. Where is my Depp? We need our actual malice definition stat. All right. We're controlling Fing ourselves. Actual malice. All right. Let's see. Where is it? All right. We're all going to look for actual malice together. It's in here somewhere. And it's not, I don't know why it stopped highlighting it for me. We need our definition of actual malice. That's not it. That's not it. That's not it. That's not it. Where's our defamation? Definition of defamation. Let's see. I don't know why it's not finding it for me. It's really annoying. Let's see. Malice, malice, malice. These are all the finding instructions. I need the other instruction. Ugh, this is so annoying. Defamation by implication. Defamatory meaning. Should be right here. Actual malice. There it is. I don't know why this didn't pull it up. All right. Actual malice. Let's just go over this together so we're all here. We'll fix it in post, I swear. The parties have the burden of proving actual malice with knowledge that the statement was false or so reckless as to amount to a willful disregard for the truth, with a high degree of awareness that the statement was probably false. Ask yourself, they're arguing knowledge. They're arguing in their motion that Depp had to prove knowledge. This gives two options, knowledge and recklessness. Could a jury have found that Amber Heard's statements were reckless based on what her evidence was presented? Yes. Could the jury have found that there was a high degree of awareness that the statement was probably false? Yeah. Based on the trial I watched, I think they could. Did the jury have to define whether they found knowing the statement was false or reckless and willful disregard? No, they don't. They don't have to say which one it is. So, no, this is a misstatement. In this motion, this is a misstatement of the law, I think. It's like my opinion, Elaine, that you are actually misstating what the jury had to find, just like you misstated it in your closing arguments, which leads me to believe that you still don't understand what actually needed to be proven in this trial, which is concerning. Which is concerning. For the jury to find Miss Heard demonstrated actual malice, Depp was required to establish that at the time the op-ed was published, Miss Heard did not believe she had been abused. But Mr. Depp presented no evidence that Heard did not believe she was abused. Instead, the evidence overwhelmingly supported Miss Heard believed she was the victim of abuse at the hands of Mr. Depp. Therefore, Mr. Depp did not meet the legal requirements for actual malice. The verdict should be set aside. I mean, keep throwing spaghetti at the wall, man. Brenda said they are so stuck on the UK they can't see daylight. Brenda, this is an excellent point, and I think this is actually what hurt their case in the US. Is I think they tried this case similar to the way they tried it in the UK, which was to lean into Johnny Depp's substance abuse, and the judge did not. The judge did not give any leeway for substance abuse. The judge was like, no, Depp was using, I don't believe him. So they tried this case like that, and the jury was like, no, man, no. I think they relied on the win in the UK to their detriment, thinking that this jury would see things the way the court in the UK did. But the court in the UK didn't have all the information that came in the US case. I don't think they reset themselves for the US case. I think they tried to just duplicate the UK case, and that did not work. Finally, the information on the jury panel list appears to be inconsistent with the identity and demographics of one of the jurors. Juror number 15 was apparently born in 1970, not 1945, as reported to and relied upon by the parties, including Miss Heard, in selecting the jury panel. This should have come up when they were selecting the jurors. Given the requirements for verification of each juror, it appears the identity of the juror was not verified. It is unclear if juror number 15 was in fact ever summoned for jury duty or qualified to serve on the panel. This warrants an investigation by the court to determine if the juror was in fact summoned and whether the due process rights of the parties were bypassed. Depending upon the results of the investigation, this may justify setting aside the verdict in its entirety and setting this matter for a new trial. No, because there's nothing there that argues that this juror didn't come before the court and get vetted. We didn't see voir dire in this case. We did not see jury selection. But what we do know from juror selection is that they would have gotten questionnaires. The questionnaire pool would have been narrowed down. The jurors would have come in and be questioned by the court and the lawyers. And they would have had this information then. They would have had this knowledge then. They would have had the juror list. They would have had the jurors there, and they could have questioned them at that time. But again, attack the jurors seems to be the argument of the day. Argument: the damages awarded by the jury are unsupported by the evidence and the law. The jury returned a verdict of 15 mil. Yep. The punitive damages award was reduced to the statutory cap. Yep. The damages awards were unsupported by the evidence presented at trial and cannot be upheld. How do you get there? Tell me how we get there. Under Virginia Code 8.01-383, where damages awarded are too small or too excessive, courts have the authority to order a new trial on all issues or solely the issue of damages or remediator. We're not going to get into remediator. It's not a type of dinosaur. We don't need to do that today. While as a general rule, a trial court should not disturb a jury, a jury award that has been fairly rendered and based on competent evidence. Quote, courts have a duty to correct a verdict that plainly appears to be unfair or would result in a miscarriage of justice. What are the guesses that Judge A isn't going to find that here? This is a big old nope. This is going to be a big old nope sandwich. This was a lawsuit for $50 million and $100 million respectively. A $10 million award is not outside the realm of possibility here. Circumstances which compel setting aside a jury verdict include a damage award that is so excessive that it shocks the conscience of the court. Judge A, are you shooketh? Are you shooketh? They asked for 50 million. They got 15. That's really 10.3. Who's shook? Are any of you shook? I was surprised by 10 mil. Truly, I was. But I'm not quaking based on the lost rolls that were alleged. Are you? Anyone who's shook, let me know in the chat. I want to know if you were shook by that 10 million. Has it rattled your conscience? Were you like, oh my God, how did you even get to that number? Here, the jury's let's start that over. Here, the jury's determination of 10 million in compensatory damage is excessive as a matter of law, as there is no evidence to support the verdict. Mr. Depp was limited to damages from December 18th, 2018, the date of the op-ed, through November 2nd, 2020, the date the court ruled in the UK that Mr. Depp had committed at least 12 acts of domestic violence, including sexual violence, which is why he didn't bring up the Fantastic Beast rule, because the Fantastic Beast rule was lost after the UK verdict. So this took the Fantastic Beast rule out of consideration for damages. And a lot of us were having this conversation. I wish I had put the timing together before this motion. A lot of us were having this conversation like, oh, they didn't even bring up Fantastic Beast. Well, now we know why. There was a ruling limiting damages, and we heard Elaine saying damages up to this date. But the dates in this case were so fucking fuzzy half the time. There were days I was like, where are we in time? Like, I felt like we were literally time traveling throughout this trial, and I wasn't sure where exactly in time we were. So that's why the Fantastic Beast amount didn't come up. But we did have expert testimony about the 20 plus million for pirates, and that was lost in this time period. That's what his agent testified to. That's what Richard Marks testified to. Okay. And you guys are mentioning he got paid for Fantastic Beast. Yes, he did get paid for Fantastic Beast, but it was after. I think there's an argument that when he lost Fantastic Beast, he lost futures in the franchises, and that there was an argument for that. But the timing of it was that he lost that franchise after this, so it doesn't matter that he lost future work, if that makes sense. That's where my brain is, anyway. Let's see. Oh, they're going to say this again. Okay. Mr. Depp was limited to damages from December 18th, 18, November 2, 20, the date the court ruled in the United Kingdom that Mr. Depp had committed at least 12 acts of domestic violence, including sexual violence, at times causing Ms. Heard to fear for her life. The court, during opening statements in response to Mr. Depp's objection, prohibited Ms. Heard from telling the jury about the Sun article, which was published in April 2018. Defendant's Exhibit 99, nearly 8 months before the op-ed in the trial. Nearly 8 months before the op-ed, the trial in July 2020. During the limited period, Mr. Depp was able to claim damages. The claimant filed. What is happening? The claimant filed by Mr. Depp in June 2018, alleging irreparable damage to his reputation, Defense Exhibit 1599. The 3-week trial on Mr. Depp's libel claims, the ensuing publicity surrounding the trial, or the UK judgment. 128-page, 585-paragraph document issued on November 2, 2020. Where are we? What just happened? What? Okay. The court, during opening statements in response to Mr. Depp's objection, prohibited Ms. Heard from telling the jury about the Sun article. But what else? Okay. Apparently, they were not allowed to talk about the Sun article or the complaint filed in. I'm so confused. All right. Apparently, the court ruled about all of that. After many of Mr. Depp's witnesses had testified, the court then allowed Ms. Heard to raise but not admit into evidence the Sun article, the fact of the trial, and the publicity surrounding the trial, but still not the UK judgment. 42922 hearing transcript. In an effort to prevent the UK judgment from coming into evidence, Mr. Depp represented he would not attempt to claim any damages after November 2nd, 2020. Hearing transcript from that hearing. Notwithstanding Mr. Depp's representation, he would not attempt to claim any damages other than the period of December 18th through November 2nd. Mr. Depp made no attempt to limit his damages, and his counsel in closing made it clear that they were seeking damages from May 27, 2016, the date Ms. Heard sought and obtained the DV temporary restraining order through present. This was highly prejudicial to Ms. Heard, necessarily creating confusion for the jury. Well, not necessarily. And resulting in a $10 million compensatory and $5 million punitive award that reflected the jury's belief that they were restoring Mr. Depp's reputation based on Ms. Heard's initial filing. How do you know? This alone justifies setting aside the verdict and ordering a new trial. The fuck it does. The fuck it does. The fuck it does. A, you don't know that. B, they were not arguing damages during that time. They were arguing the 2 years prior and the reference and restoring Johnny Depp's reputation with a liability finding. That argument was not about damages. When they got to damages, do you know what they said? When they got to damages, what they said was, we want you to restore his name. We're not here to bankrupt or impoverish Ms. Heard, something in those characters. Like, we're not here seeking money. What we're here seeking is Mr. Depp's reputation, and you can restore that with a liability finding. They, in fact, downplayed damages so much that they didn't even ask for a number. Mr. Depp presented no evidence of any pecuniary damages suffered in the limited time frame as a result of the op-ed. There was no evidence of any projects or lost commercial opportunities because of the op-ed. There was though. What? But there was though. Like all of Richard Marx's testimony. Okay. Moreover, Mr. Depp cannot demonstrate any reputational damages from the op-ed because the evidence, including Depp's own testimony, was that Mr. Depp lost nothing less than everything. As of May 27, 2016, when Ms. Heard obtained the DVTRO against him, and that then there were 2 years of constant worldwide talk about Mr. Depp being this wife beater before the op-ed was even published, including the Sun wife beater article. In addition, any reputational damage after the op-ed, which never mentioned Mr. Depp's name, they're really hung up on that, would have been non-existent or at best nominal compared to the Sun article, the lawsuit brought by Mr. Depp, the publicity over Mr. Depp's lawsuit against the Sun in the United Kingdom and subsequent trial and judgment rendered against Mr. Depp. So what they're trying to argue is that it was the TRO that cost him everything. So there's no damage from the op-ed. You wrecked yourself before it. So there's no damage. The thing is, they needed to argue that to the jury better. And Elaine was so caught up that Emily opinion rant incoming. Elaine was so caught up in proving the facts of each little facet of each incident. And then on the plane, and then she had the Amica cream, and then she carried this, and people came in and lied. Elaine was so caught up in those facts and talking about those facts that they never well set out this timeline to say Mr. Depp's reputation was damaged before the op-ed was ever written, therefore there was no damage. Rottenborn wanted to do that. He started it in his opening with a very legal and technical argument. But then Elaine and Heard went into the facts so specifically that that's what they wanted to prove to the jury. And they lost sight, even in their closing, of these timelines. They needed to hammer on this through the jury and to the jury. And Rottenborn tried to, but they needed to narrow their arguments to this. And they didn't. They wanted to fight every single factual allegation. And in that, the legal arguments were lost. These are the legal arguments where they could have said to the jury, yeah, Mr. Depp says he lost nothing less of everything as of 2016. So there was no damage done in 2018. But they didn't. And when Depp was asked about what the op-ed cost him, I believe the answer was nothing short of everything. But I believe it was in response to Jessica's question about what did the op-ed cost you? But this is for the jury to decide. This is not cause for a do-over. This is inartful lawyering, and you don't get another crack at it. The jury, they tried to make this argument. And I'm sure if we went through the transcript of the closing, it was in there somewhere. But the closing from Team Heard was hard to follow. It was not linear. There was an Amber Alert in the middle of it. And then Elaine's rambling, like frenetic, like pace that was scattered. It got lost. But that's not grounds for a new trial. So you get a do-over. There is no do-over. There's no game off, game on here. All right. I don't know where this footnote came from. Let's see if we can find it.
Sorry. Could you say that again?
No.
Sorry.
Siri just wanting to have a say for a moment. Let's see. This footnote goes to, in an effort to prevent the UK judgment from coming into evidence, Depp represented he would not attempt to claim damages. Footnote 1. Let's go to footnote 1. In spite of Mr. Depp's representation that it would not seek it would not seek? Who's it? Wait, is Depp the it? What is happening? In spite of Mr. Depp's representation that it would not seek to introduce or claim any damages to Mr. Depp after November 2, 2020, Ms. Heard never agreed that limiting Mr. Depp's damages would obviate the need for the UK decision to be referenced and admitted into the trial, and instead repeatedly requested the court to reconsider and admit the UK judgment into the trial. And the court denied your request. The request is going to continue to be denied. Denied! 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 Wow. Let's see. In addition, any reputational damage after the op-ed, which never mentioned Mr. Depp's name, we can't get over it. Just in case any of you want to know, it can be defamatory without saying someone's name. Defamation by implication is a thing. Not mentioning someone's name doesn't mean you can't reference them enough so that everyone is like, we understand the defamatory purpose. That's what the experts came in to testify about in this case. And we will see it in other defamation cases that we need to circle back to. You don't have to say someone's name to defame them. Yes, it traditionally makes it harder, but you had multiple experts coming in saying everyone knew what she was talking about because she said 2 years ago. The timing became more of the thing. But okay, make your arguments, like go off. At least they're not done making these arguments. They're going to keep making these arguments. They've made them on television. They've made them in articles. The press has repeated them. They're not done. Like every mainstream media outlet that's like, and it never said his name. So fucking what? It's defamation by implication. That's a thing. Ask your legal experts at your networks. Ask them about defamation by implication. Yes, it is deeply legal, but yes, it's still a thing. Ugh. This is why people watch us on the YouTubes, because we explain to you that it's a thing. It's a thing. You're not safe just because you didn't say someone's name. Me going, should I come up with an example? No, because taken out of context, it would be an issue. Should we start defaming fictional characters? No, because then somebody will say it's a trademark issue. Okay. Let's see. Moreover, the exclusion of the UK judgment necessarily prevents any reasonable or competent assessment of any damages. It doesn't, though. It doesn't, though. It's trying to subvert the jury's decision by telling them a judge decided. It doesn't help. The UK judgment's irrelevant to damages in this context. Why? Just why? The exclusion of the UK judgment necessarily prevents any reasonable or competent assessment of any damages, including reputational damages, as well as the credibility of Mr. Depp in asserting damages. How? There is no way a jury can determine any level of damage to Mr. Depp from the op-ed without taking into consideration all potential alternative causes of damages, much less an overriding one brought on at Mr. Depp's election to file a libel suit in a form of his choosing. Well, he kind of had to sue them there because that's where they are, claiming irreparable damages to his reputation from the Sun article. There can be no damages reasonably tied to the op-ed, much less 10 million. It is excessive as a matter of law and should be set aside. False. Denied. Move on. But here's the thing. When you go through last week's podcast episode, you will see why the court talks about these being totally different things. What was said in the Sun UK is different than Amber Heard saying it. They had expert testimony on this. Her experts talked about it. Her experts talked about Johnny Depp bringing lawsuits and the lawsuits potentially being something that marred his reputation. It's not like none of this came up in the trial, Elaine. This came up. The jury considered it. You cross-examined his experts. You brought in his own experts. You brought in his former manager that talked about these lawsuits damaging his reputation. It came up. The fact that there was a judgment didn't come up, but the rest of it came up. The wife beater headline came up. Other articles came up. Richard Marks testified, and I need to pull back out my trial notebook to go over this shit, but Richard Marks testified, to the best of my memory, that a gossip magazine or a gossip rag or whatever, the Sun UK, has a different weight in Hollywood than a first-hand account in the Washington Post via an op-ed, and that those things have tremendously different weight. Because when you read the Sun UK, aren't you just going like, okay, isn't that some tea? But are you really going with like, oh, that's the absolute truth? That's what the experts are for. And that's what Heard's experts were trying to rebut. Heard's experts were trying to say that the damage was already done. The shit was already out of the horse. And Depp's experts did the same thing against Heard when Heard was saying she had reputational damages from the Waldman statements. They were saying, girl, you already wrecked yourself. This is already done. And Ms. said, Mark said the Sun was a rag, but that the WAPO was listened to. And it's different. A first-hand account is different than kind of a gossip, different than gossip. It's just different. God, we have to keep going. We're never going to finish. Emily, should you have done no quick bits today? Yes. Does it matter? No, we're going to keep going. It's just, we're going to keep going. Moreover, the exclusion of the UK judgment necessarily prevents a reasonable, competent assessment of damages. I disagree. There is no evidence of pecuniary damages from the op-ed. Taking the evidence in the light most favorable to JD, there is no evidence upon which a jury could have reasonably relied to determine that JD suffered any pecuniary loss. How? While Mr. Depp asserted he lost Pirates 6 because of the op-ed, there's no evidence upon which the jury can rely to reach such a conclusion. There's testimony. Mr. Depp did not have a contract for Pirates 6. There was media coverage that Mr. Depp would not be in Pirates 6 as of October 25th, 2018, 2 months before the op-ed. Mr. Depp's agent testified that it was very likely Mr. Depp would not be in Pirates 6 as of the fall of 2018. And Mr. Depp testified that he would not have agreed to play the role in Pirates 6 for $300 million and $1 million alpacas. Moreover, the Disney corporate representative testified that Pirates 6 is still a project that's possibly in development at the studio as of the present, and that Disney would not entertain paying Mr. Depp $300 million and provide him with $1 million alpacas. That did happen. And Disney's representative further testified she did not know if Pirates 6 would ever be made. While Mr. Depp's agent testified to a deal for Mr. Depp for Pirates 6 for $22.5 million, yet also admitting that there's no writing memorializing the supposed deal, he said that Mr. Depp would not be paid until the film shoots. Mr. Wiggum's belief that there existed a contract was based on his understanding that Tracy Jacobs, Mr. Depp's earlier agent, had negotiated a deal. There's the transcript. That's not how I remember it, but this is going to be characterized in the light most favorable to AH. What I remember Wiggum testifying to is that this would be an add-on to the previous deals. So it's not that Tracy Jacobs had negotiated the entire deal for Pirates 6. It's that the previous Pirates movies have been negotiated and that this would get added on as of, and yes, here's the next. So that was already negotiated. That's how I remember it. However, Tracy Jacobs testified that there was no deal negotiated to commit and no commitment from Disney that Mr. Depp would be in Pirates 6 while she represented Mr. Depp, which was up until October 2016. See, because what I remember is that she had negotiated the previous deals and this would be an add-on contract to the previous deals. It would just be an addendum extending it. That's what I understood from Wiggum's testimony. Since the film was never shot, let alone even written, and was not by November 2, 2020, the date of Mr. Depp's damages cut off, it would be impossible for Mr. Depp to claim damages for Pirates 6. Yet Mr. Depp continued to claim this at trial. Then it's your job to point it out or to stop it. That's the adversarial process. That's how that happens. Most importantly, there's no, someone is cooking something that smells delicious in my house. And I just took a big old breath and I was like, that smells so good. What are they making? It smells delicious. I bet you my oldest is making steak. He's probably making teriyaki bowls. It smells very good. Okay. I'm distracted. Most important, there is no evidence that the op-ed had anything to do with whether Mr. Depp would be in Pirates 6. The Disney corporate representative testified that no decision maker within Disney has ever said that Disney would not cast Mr. Depp in P6 or any other Disney project because of the op-ed. That's why Richard Marks testified. In fact, while Disney had internal emails commenting on negative publicity relating to JD, including the UK trial and judgment, it had nothing in its files even referencing the op-ed, much less a copy of the op-ed. And the jury saw that. Even Mr. Marks, Mr. Depp's expert, acknowledged the article published 3 days after the UK judgment indicating that Mr. Depp was out of any further Pirates franchise. Wait, what? Acknowledged that any article published 3 days. What? Oh, acknowledged the article published 3 days after the UK judgment indicating that Mr. Depp was out of any further Pirates franchise. If the jury based any aspect of its award on Pirates 6, this would have been contrary to the evidence, prejudicially impacted by Miss Heard being prevented from introducing the judgment. I don't think those two follow. I don't think those things follow. But they're not going to know what the jury based it on. Let's see. I've got to back up because this sentence is so awkward. If the jury based any aspect of its award on Pirates 6, this would have been contrary to the evidence, in your view, prejudicially impacted by Miss Heard being prevented from introducing the November 2, 2020 judgment or the article 3 days later, purely speculative, and was effectively prohibited because Mr. Depp was limited to damages. That's a fucking word salad of a sentence that's awful. Nor is there any evidence Depp lost any other opportunities because of the op-ed. There's no evidence of any other films being lost because of the op-ed. Mr. Wiggum testified that Mr. Depp did not have any studio films between November 18 and October 2020 because he did not testify. But he did not testify that it was the op-ed that caused Mr. Depp to lose opportunities. Instead, Mr. Carino, Mr. Depp's other agent, testified that the publicity surrounding litigation was harmful to Mr. Depp's career. Mr. Depp filed the lawsuit against the son of Mr. Wooten in June 2018 and against Miss Heard in March 2019. Mr. Wiggum testified that there was a great deal of publicity surrounding the UK trial. See, it did come in. And that Mr. Depp had not been cast in any film since the UK trial. There is also no evidence of any endorsements Mr. Depp lost or did not receive because of the op-ed. In fact, Mr. Depp still has an endorsement deal with Dior, which he has had since 2015. This goes both ways, though. And it's hard because they had to be very careful. They're trying to make this argument more forcefully, and this is my thoughts on this. They're trying to make this argument more forcefully now than they made it to the jury, because when they made this argument to the jury, it cuts both ways. And they didn't want to make this argument in this way to the jury, because then it cuts the same way for Amber Heard. Amber Heard's expert said, how do you prove the things that you lost by the opportunities that stopped coming in? Like if there were opportunities out there and they're like, we're not touching that because it's a fucking shit show. How do you prove the opportunities that never came in that were lost? And that's why we saw Amber Heard's expert going through, look, this is the trajectory we would expect to see. This is what we saw from Jason Momoa and Zendaya and Gal Gadot. And this is what we expected as their experts to see for Amber Heard, this trajectory. It cuts both ways. So they didn't make these arguments that way to the jury, but that is an argument for the jury. That's not a reason to overturn the jury's judgment in this case. I'm already ready for the response. I'm already ready for the response to this. The jury's compensatory and punitive damages awards were excessive as a matter of law. Given that the jury did not and could not, would not, sir, I could not, would not eat them on a boat. I could not, would not eat them with the goat. I do not like green eggs and ham. I do not like them, Sam I am. Given that the jury could not, would not, did not award Mr. Depp damages for any financial or pecuniary losses based on the evidence at trial, the only damages the jury could have possibly awarded Mr. Depp were reputational damages. Footnote 2. At no point in his testimony or through his experts did Mr. Depp even claim damages for emotional distress. Even though I think Johnny Depp kind of talked about emotional distress, didn't you? Even though reputational damages are non-pecuniary, a jury still must award damages that resulted only from the defendant's wrong and not from other causes. Moreover, reputational damages cannot be used to punish a defendant for all of the negative publicity that a plaintiff had received separate from the alleged defamation. But that is precisely what happened here. And it was compounded by the exclusion of the evidence of the UK judgment. The UK judgment! Ah! The fact of the UK trial came in. The judgment's irrelevant. Mr. Depp is not entitled to damages for any conduct prior to the op-ed. There is no evidence of damages to Mr. Depp's reputation caused by Ms. Heard's op-ed. Instead, Mr. Depp testified that the damage to his reputation was when Ms. Heard obtained the DVTRO on May 27, 2016, for which he cannot be compensated. Mr. Depp began his testimony by informing the jury that he has brought this case because about 6 years ago, Ms. Heard made some quite heinous and disturbing, brought these certain criminal acts against me that were not based in any species of truth. Transcript, that site. JD then continued his testimony by describing how the accusations stemming from the DVTRO in 2016 spread through the media. Quote, the news of this, her accusations had sort of permeated the industry and then made its way through media and social media, became quite global, let's say, quote unquote, fact, if you will. I felt it was my responsibility to stand up not only for myself in that instance, but stand up for my children, who at the time were 14 and 16, and so they were in high school. And I thought it was diabolical that my children would have to go to school and have their friends or people in the school approach them with the infamous People magazine cover with Miss Heard with a dark bruise on her face. And then it just kept multiplying. It just kept getting bigger and bigger. Mr. Depp emphasized that his reputation had been damaged for 6 years, well before the op-ed. So it was my responsibility, I felt, not only to attempt to clear my name for the sake of, well, for many reasons, but I wanted to clear my children of this hard thing that they were having to read about their father, which was untrue. It has really taken this full 6 years. It's been 6 years of trying times. It's very strange when one day you're Cinderella, so to speak, and in 0.6 seconds, you're Quasimodo. I appreciate the references to Disney characters, though. I mean, I understand that Quasimodo is not specifically from Disney, and neither is Cinderella, but they're both portrayed by Disney. You know what I mean. Just roll with the analogy, friends. Mr. Depp's testimony clearly establishes that the damage to his reputation occurred in May 2016 and was not related to the op-ed. It's an interesting argument, but this argument needs to be made to the jury. And this was not isolated evidence. Mr. Depp also testified that after the public became aware of the DVTRO in May 2016, the bad news about him, quote, was multiplying and multiplying and multiplying throughout the media, through social media, as well, so-called sort of strike media or whatever. I don't know what that means. And I was taken aback a bit. They were abuse allegations, and then there was alcohol, and then there was drugs and violence, and it was already right then and there before my eyes, spinning out of control. Mr. Depp testified when Mr. Heard obtained the DVTRO, he lost, quote, nothing less than everything. I need to go back and look at that section in the trial because I thought it was asking a broader question, but I want to go back and look at it. Thankfully, the entire trial was actually streamed, so we can go back and look. Because when the allegations were made, when the allegations were rapidly circling the globe, telling people I was a drunken, cocaine-fueled menace who beat women, suddenly in my 50s, it's over. You're done. This negative publicity in 2016 included articles from TMZ and People magazine that showed photos of abuse alleged by Miss Heard, which Mr. Depp introduced into evidence in the case. The negative publicity about Mr. Depp before Amber Heard's op-ed included headlines such as, and this is stuff Amber Heard's team brought in, and these are the headlines. Apparently drunk Johnny Depp cut off at Hollywood Film Awards ceremony. Johnny Depp, friends and family seriously concerned about him years wide. None of these have dates. These were brought in by Heard. And again, there was expert testimony about these things. And then there's the last one, which is the UK Sun headline that he sued over. How can J.K. Rowling be genuinely happy casting wife beater Johnny Depp? Mr. Depp admitted that these articles were not because of Miss Heard's op-ed, though they could not have been. No, they were predicating it, but based on the allegations. Let's see. All of this started with Miss Heard going directly to court to get a TRO, which is with a bruise on her face and paparazzi. That was the sort of beginning of the ball rolling downhill and gaining momentum. After 6 weeks of trial, Depp went back up on the stand, reiterated this testimony to the jury, stating that Miss Heard's actions on May 27, 2016 changed everything because it's what she referenced in the op-ed. It's what's referenced 2 years ago. That's what referenced it. He again did not state that it was the op-ed that damaged him, but the accusations from May 2016 that the op-ed references. He again did not state that it was the op-ed that damaged him, but the accusations from May 2016, claiming I have spoken up for what I've been carrying on my back reluctantly for 6 years. Mr. Depp did not only rely on his own testimony to claim damages from May 2016 forward. Doug Banya, an expert hired by Depp, was, quote, asked to analyze the impact of the allegations of domestic abuse made by Miss Heard as it related to her 2016 restraining order, and then asked to analyze the publication of that alleged abuse in her 2018 op-ed. Banya testified that his analysis shows that prior to 2016 and the abuse allegations, Mr. Depp was not portrayed in a negative connotation. After the 2016 mark, the majority of those results turned into negative things about the abuse allegations, and then even more so after the op-ed. There seemed to be kind of a theme or a flavor of not only the abuse allegations, but his drinking and drug use. Because Banya did talk about, like, from 2016 to 2018, it was this and then this. But Mr. Banya admitted that his analysis cannot separate how Mr. Depp's reputation was impacted from the op-ed versus how it was impacted when Miss Heard filed for divorce. This means, as Mr. Banya admitted, that Mr. Depp's expert cannot say, that Mr. Depp's reputation or public image was affected by the op-ed. No, that expert didn't. That's why there were multiple experts. Okay. In fact, Banya testified that Mr. Depp's Q scores, both positive and negative, actually improved after Miss Heard's op-ed, meaning his reputation and public image actually improved after the op-ed in 2020, which again, Mr. Banya admitted. Other things happened, but okay. Finally, Mr. Depp's counsel improperly emphasized to the jury that it could find damages based on Miss Heard's obtaining the DVTRO. Counsel began Mr. Depp's closing argument not by discussing the op-ed, but by stating, oh, you want to talk about improper argument? You want to talk about improper argument in closing? This is the argument you want to bring before the court? Really? This one? This is the one? Sure. On May 27, 2016, Ms. Heard walked into a courthouse in Los Angeles, California to get a non-notice ex-parte restraining order against Mr. Depp, and in doing so ruined his life by falsely telling the world that she was a survivor of domestic abuse at the hands of Mr. Depp. Today, on May 27, 2022, exactly 6 years later, we ask you to give Mr. Depp his life back by telling the world that Mr. Depp is not the abuser Ms. Heard said he is, and hold Ms. Heard accountable for her lies. Counsel for Mr. Depp then went on to tell the jury that Ms. Heard seeking the DVTRO was not based in truth and was instead designed to ruin Mr. Depp. Quote, when she walked into court 6 years ago today on May 27, 2016 to get a domestic violence restraining order against Mr. Depp, she did so in front of the paparazzi with a mark on her face. The evidence presented at this trial demonstrates that Ms. Heard didn't just want a divorce. She wanted to ruin him. Like Mr. Depp's testimony and the evidence offered throughout the case, these were not isolated remarks, but permeated the entire closing, that Ms. Heard should be held responsible for seeking the DVTRO in 2016. That's when his life ended. That was 6 years ago to this day when Ms. Heard on May 27, 2016 walked into court with her publicist, Jody Gottlieb, having tipped off TMZ with an alleged mark on her face to accuse Mr. Depp of abuse. It was about Mr. Depp's reputation and freeing him from the prison in which he's lived the last 6 years. And it's 6 years to the day. Reputation is not damages. You heard from Mr. Depp yesterday that he's been carrying these outlandish, outrageous stories on his back pretty stoically and living with them for 6 years and waiting to be able to bring the truth back. The emphasis of this closing was clear. Mr. Depp was asking the jury to compensate him. No, they were asking for liability to compensate him for actions that occurred on May 27, 2016, actions which he has no right to damages. This is improper and calls for this court to set aside the verdict. No. They're quoting a case saying, why are they putting it in paren though? Like if you're quoting the case, why is it in okay. The court has a substantial concern that the jury's decision was a result of an attempt by them not merely to compensate, but to punish defendant for her remarks about a personal matter on public airwaves. Moreover, it appears that they intend to punish her for all of the negative publicity that plaintiff had received and not just effects of one interview in March 2016. This is from another case. I don't know why it's in parentheses. Mr. Depp is not entitled to damages for alternative causes, including the Sun publication, the ensuing litigation brought by Mr. Depp, the UK trial, and surrounding publicity. Fair. The evidence demonstrates that any damages caused to Mr. Depp after the op-ed were not because of the op-ed. There were a number of alternative causalities. The most significant was surrounding the Sun's April 2018 publication in the UK for the article by Dan Wooten entitled "We've Gone Through It," and the ensuing lawsuit, trial, and judgment. Depp brought a lawsuit against Wooten in the Sun, we know. 6 months before the op-ed. Yeah, for different statements in a different country with different rules. We've been over this so many times. The Sun, the Sun, the Sun, the Sun, the Sun. We've been over it. Depp wanted to clear his name. Yes, the Sun called him a wife beater. That's different than what Amber Heard said. They go back to Mr. Banya's analysis. They go back to the headlines that came up. They say Mr. Depp cannot, as a matter of law, be compensated for any injuries caused by anything associated with the Sun publication, the UK's lawsuit, and the trial in the UK judgment. Yet Mr. Depp's expert, Mr. Banya, well, he had multiple experts, could not separate out how Mr. Depp's reputation was impacted from the op-ed versus the publicity surrounding the UK litigation. But Richard Marx did. Finally, Mr. Depp claimed in his testimony that he has been damaged for the past 6 years, including through this jury verdict. Huh? Someone make that sentence make sense for me. My brain's tired. Finally, Mr. Depp claimed in his testimony that he has been damaged for the past 6 years, including through this jury verdict. The verdict that hadn't happened yet? How could he claim in his testimony that he's damaged by a verdict that hasn't happened? Huh. Okay, this repeats what they just said about Depp stoically carrying this on his back. This completely defied Mr. Depp's representation to the court that Mr. Depp was only going to claim damages from December 18th, 2018 through November 2, 2020. Define damages. Define damages then. Are you just talking about monetary damages? Because that's what I'm talking about. Oh, God. It is eminently unfair and prejudicial for the jury to be told repeatedly that Mr. Depp was damaged for 6 years up until present, while Mr. Depp represented to the court that it was not claiming such damages. They keep calling Johnny Depp it. Why is that? Why do they keep saying it? Chat, help me out. Did they cut and paste this from talking about a corporation? Because they keep referring to Johnny Depp as it. Well, Mr. Depp represented to the court that it was not claiming such damages. Why? Why it? Did they think no one would notice? The prejudice is exponentially increased because Ms. Heard was denied the ability to introduce the evidence that Mr. Depp's lawsuit against the son of Mr. Wooten resulted in an extensive 129-page judgment finding that Mr. Depp committed 12 acts of domestic violence against Ms. Heard, including sexual violence, and it caused Ms. Heard to fear for her life. Deaf. Period. The jury's verdict as to damages should be set aside. Deaf not. Yikes. They really are angry about the UK case. Virginia case law supports setting aside damages judgments that are excessive. Does anyone think it's excessive? There have been several cases that have found damages to be excessive in defamation cases, which are instructive here. While, quote, each case must be determined by its own facts, it is nevertheless true that the verdicts of other juries which have been approved by the courts represent the common or average judgment of mankind as to the proper recovery in such cases. Then there's this one, finding a verdict of $10 million to be excessive and multiple times the amount of any other damages award for defamation in Virginia. These go case by case. For example, Richmond Newspapers versus Lipscomb. The Virginia Supreme Court sustained a remitter of $900,000 from $1 million. Really? They dropped it 10,000 or 100,000? Sorry. From $1 million to 900,000. Compensatory damages for defamation arising out of the publication of a front page article in the Richmond Times-Dispatch, not the Washington Post, which reported on complaints about plaintiff's performance as a teacher. What? Are they? Wait. Look, I have the utmost respect for teachers. My father is an educator. I have the utmost respect for teachers. But the amount a teacher can stand to lose based on the fact that they are grossly underpaid and the amount a celebrity stands to lose are not comparable. Celebrities, highly paid. Teachers, underpaid. So please don't take offense when I say that these are not comparable. They're not comparable because the salaries are just not comparable at all. While the court affirmed the judgment that the teacher was defamed, it held that an award of $1 million clearly would have been excessive. The evidence does not demonstrate at trial that the trial court abused its discretion of reducing the award to $100,000. Oh, so it remitted the $900,000 down to $100,000. Okay, but it's different. In the Gazette, these are distinguishable cases. In Gazette Inc. versus Harris, the jury awarded compensatory damages of $100,000 for publication of an advertisement accusing plaintiff of racism in the campus newspaper of the university where plaintiff was a professor. The Virginia Supreme Court held that $100,000 in damages bore no relationship to the loss sustained by plaintiff. The verdict of $100K is out of proportion to the damage sustained as to be excessive as a matter of law. Well, that's the court's determination. The verdict is $100,000 is so out of proportion to the damage sustained to be excessive as a matter of law. As the defendant points out, Moore experienced no physical manifestation of any emotional distress, so they were seeking a different kind of damages. Moreover, he sought no medical attention for any condition resulting from the publication. There was no evidence that Moore's standing with his peers was diminished as a result of the libel. Actually, the evidence showed that Moore continues to be held in high esteem in the community. Those are distinguishable. Similarly, Mr. Depp can point to no damages sustained from the op-ed as opposed to other unrelated events. The $10 million verdict is completely out of proportion with anything even remotely related to the op-ed, especially in light of the Sun article, the lawsuit filed by Mr. Depp, and of course, the UK judgment. They're going to 2 circuit cases that are probably likely distinguishable, so we're skipping them in the interest of time and sanity. Let's see. Back to Mr. Depp. Here, the jury's award of $10 million is not commensurate with the damages purportedly caused by Ms. Heard's op-ed, but rather appear to punish her for all the alleged harm caused to Mr. Depp for the past 6 years, beginning with the May 27th DVTRO, for which Mr. Depp was not entitled to receive damages. The same is true for the $5 million punitive damages. There was obviously a sense to punish Ms. Heard for something far beyond the op-ed. Lying. It was for lying. It was lying. Lying is what they were seeking to punish. The op-ed is where those lies were told. And the trial. I mean, it wasn't limited to the op-ed. Finally, in Sheckler versus Virginia Board Corp., the court found an award of damages of $10 million in a defamation case to be excessive and reduced the award to $1 million. There, a broadcast corporation through its TV station aired inaccurate information regarding plaintiff's arrest for conspiracy to distribute cocaine, namely that law enforcement officers found 50 grams of crack cocaine and 500 grams of powder cocaine at his residence and business. Despite finding the defamation, the court significantly reduced the damages award because it found that the defendant could not be held responsible only for those injuries inflicted by the defamatory portions of the broadcast, not the losses or injuries sustained from the attendant arrest, prosecution, and forfeiture. Well, duh. I mean, if you can only hold the defamatory portion, but here we're not dealing with an attendant arrest, prosecution, or forfeiture. Okay, these are distinguishable, and we're going to move past the distinguishable case law. They're arguing about closing again. In fact, Mr. Depp's closing asked the jury to clear his name for everything from 2016 forward. That's asking for a liability finding, not damages. In fact, Mr. Depp's closing asked the jury to clear his name for everything from 2016 forward, which the court in Sheckler held was error. According to the excessive award, quote, is supported by a review of plaintiff's counsel remarks in summation. Instead of asking for compensation for proven losses, plaintiff's counsel without objection asked the jury to require the defendant television station to pay an enormous sum of money to clear Mr. Sheckler's good name. They didn't ask for that. Mr. Depp's counsel asked the jury to give Mr. Depp his life back. They didn't ask for money. By referring not to the op-ed, but referring back to the May 27, 2016. On May 27, 2016, Ms. Heard walked into a courthouse in Los Angeles. Oh, they've pulled the just exact same quote over and over. Damages in this case cannot be based on actions from 2016 or any damages that Depp suffered because of the trial in the UK. But the jury's $10 million judgment for reputational damages clearly showed that that's what the jury did. Such an award is excessive by law should be set aside. I can't wait till we get a ruling on this. The verdicts in the complaint and counterclaim are inconsistent and therefore should be set aside. All right, I'm going to swoop this so we can at least parse out the different parts of the argument. Let's get to the inconsistent verdicts, shall we? The Virginia Supreme Court has held that jury verdicts that are irreconcilably inconsistent cannot stand. That's not the case here, in my opinion. In that case, the Supreme Court instructed a new trial is necessary when portions of the jury verdict are irreconcilable. Holding that a jury verdict is inconsistent, which in such form requires a new trial on all issues. After hearing the evidence, when I first started looking at this case, I was like, I can't see how they could find for both. But after hearing the evidence in this case, I understand how we got to this jury verdict. Like, I get it. I get it. And we're going to go through it and I'll tell you why I get it. All right. The verdicts found that Mr. Depp did not abuse Miss Heard at any time, while at the same time necessarily found that Miss Heard did not lie about being a victim of domestic abuse. False! And in particular, abuse that occurred on May 21st, 2016. These findings are inconsistent. You've misstated the findings, Elaine. That's not what the findings say. Let's all just remind ourselves real quick what the findings actually say. Hold on. Let's just go back to the finding instruction, because that's not true. All right, let's go to Waldman's statement, because Waldman's statement is specific. This is the statement. Quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine, roughed the place up, got their stories straight under the direction of a lawyer and publicist, and then placed a second call to 911. That's not how the evidence came in about what happened there. That says that this hoax involved roughing the place up and calling the police back out. But the second set of police officers that came out didn't see property damages, didn't see wine, didn't see the place wrapped up. So if they're basing this off of what the police said, then they're basing this off of the second set of police saying there wasn't a second call. And they're basing it off of the police not seeing the place wrapped up, their stories straight, and the spilling wine. That's not inconsistent. I don't think. And I don't think that is what's stated here, because they said they necessarily found that Miss Heard did not lie about being a victim of domestic abuse. No, they found that the police did not see that a little wine was spilt, the place was wrapped up, and a second call was placed. That's what they're saying. That's what they're saying. This is just disingenuous. It's just a disingenuous argument, because that's not what the jury verdict says, and that's not what the finding says. Okay. The findings aren't inconsistent. In overruling Miss Heard's demur, this court held that the statements, Amber Heard, I spoke up against sexual violence and faced our culture's wrath, that has to change. Then 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. And I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. All could convey the same meaning that Mr. Depp abused Miss Heard. 3/27/20 opinion letter. In reaching that conclusion, the court held that the inference could be made based on the events surrounding the parties' divorce, including the allegations from May 2016, because that's the context. This holding means that for the jury to have found that in Mr. Depp's favor as to his defamation claims, it necessarily had to find that Mr. Depp did not abuse Miss Heard at any time, including in May 21, 2016. That holding doesn't hold for what the jury believed, though. The jury gets to decide. The judge's ruling on the demur, I don't even know what you're arguing here. Like, what are you arguing? You're arguing that the court's ruling on the demur, Jesus, answering this is going to suck. They're going to be like, what are you even saying? They're arguing that the court's holding means that the jury had to find that Mr. Depp did not abuse Miss Heard. The court's ruling doesn't mean that. Ugh, that entire paragraph needs to just be yeeted. Conversely, when this court overruled Mr. Depp's demur to Ms. Heard's counterclaim, it held that the statement made on April 27, 2020 about the May 21st, 2016 incident, footnote 4, quote, implies that Ms. Heard lied and perjured herself when she appeared before a court in 2016 to obtain a restraining order against Mr. Depp. No. Moreover, it implies that she lied about being a victim of domestic abuse. 1/4/21 opinion letter 6. This holding means that this holding is not what the jury found. This is what the court ruled on demurs when taking things in the light most favorable to the opposing party. These are demur rulings. These rulings weren't told to the jury. The jury doesn't know what's in the judge's brain. Judge A didn't say, hey, jury, this is what I thought it meant. The jury decides the facts. They're the finders of fact. The two aren't the same. They're not analogous. They're not related. They're not the same. Objection? What the fuck? All right, let's go to this footnote. The full statement is here, quote, quite simply, this was an ambush, a hoax. Oh, we already read that. But what the court said is not related to what the jury found. And they're trying to say, well, because the court ruled this, it means therefore that the jury ruled this. No, that's not what it means. The way the court sees something to rule on questions of law is different than what the jury decides finding questions of fact. Facts versus law. I understand trying to make fetch happen, but this is pushing fetch too far. So the court's determination in a legal motion has no bearing on what the jury decided. Just fuck off with that. Mr. Depp himself acknowledged before the trial that the parties' defamation claims are mirror images of each other. Quote, this case is unique. It involves two essentially mirror image defamation claims asserted against the only two people who truly know whether the statements at issue are true or false. If Mr. Depp did not abuse Ms. Heard, she indisputably knows her claim that he did is false. That's the argument about malice, by the way. If Mr. Depp did abuse Ms. Heard during their brief marriage, he knows that Mr. Waldman's statements calling Ms. Heard a liar are false. The hoax claim is different. As Mr. Depp's own brief makes clear, the parties' claims against each other necessarily imply that Mr. Depp either did or did not abuse Ms. Heard. But by finding defamation against both parties, the jury necessarily found both that Mr. Depp did not abuse Ms. Heard and at the same time that Mr. Depp did abuse Ms. Heard. No. Where in Waldman's statement does it say that Mr. Depp abused Ms. Heard? Somebody help me find it because I don't see it. They are trying to make it happen and it's not happening. This is saying that on this day, they did not get their story straight and rough the place up and call the police back because that's not what happened based on the evidence. All right, I lost my place in my ranting. Let's see, because that's not what that says. As Mr. Depp's brief makes clear, the parties' claims against each other necessarily imply that Mr. Depp either did or did not abuse Ms. Heard. By finding defamation against both parties, the jury necessarily found that Mr. Depp did not abuse Ms. Heard, and at the same time, Mr. Depp did abuse Ms. Heard. No, that's not what it says. Thus, these verdicts are irreconcilably inconsistent and therefore cannot stand denied. That's just not the way the court's going to see it. That's not the way the court's going to see it. The First Amendment bars recovery for defamation by implication when the statements at issue are true. That's true. The First Amendment bars recovery for defamation by implication when the statements at issue are true on their face and involve a public figure or matters of public concern. Oh, that's reaching. What they're trying to argue in this heading, and we'll get into their arguments, what they're trying to argue is that if the statements are true on their face, there can be no defamatory meaning if it's a public figure regarding a matter of public concern. No. But keep stretching out for that reach. The Supreme Court of Virginia has never decided whether facially true statements can support a claim of defamation by implication when they involve a public figure or matters of public concern. In Pendleton versus Newsom, however, the court signaled that this doctrine does not apply in these circumstances. There, the court distinguished Chapin versus Knight Rider, Inc. I'm curious. Where the Fourth Circuit held that their speech at issue did not impart a defamatory implication. Well, here they found that the speech did impart a defamatory implication. They reasoned in Chapman, the court considered a libel claim in which the defendants were members of the press, the plaintiffs were public figures, and the subject matter touched on matters of public concern, controversy regarding involvement of American troops in the Persian Gulf War. In these circumstances, the court held the constitutional protection of the press reaches its apogee. Here, by contrast, the plaintiff was not a public figure. Oh, that is a reach. The defendants were employed by the government agencies and were not officials. Oh, okay. Y'all, I'm going to make this small. This next page is scanned so blurry that it looks like me reading without my glasses on. So I'm just going to make it small. That's the scanning on the next page. It is so blurry. It's awful. It's going to hurt my eyes. The next page is going to be a struggle for me. They say here, by contrast, the plaintiff was not a public figure. The defendants were employed by government agencies and were not officials generally known. The publicity attending the subject matter lasted only a few days, and the freedom of press is in no way imparted or impacted. That's distinguishable. And by distinguishable, I mean that holding and those facts are so different from this holding and this facts that it doesn't make the court rule one way because it's different. Let's see. Several jurisdictions have held defamation by implication is not recognized as a viable cause of action where the statements at issue concern public figures or matters of public concern. And this is a case. This is not from Virginia. This is not from Virginia. This is not from Virginia. So these are cases from other jurisdictions because this, they're saying, is again an issue of first impression in Virginia, meaning a Virginia court has not decided this matter, whether or not defamation by implication exists with regard to public figures of matters of public concern. So that's the first impression. Virginia has not decided it. So here are some other cases from other jurisdictions. Several jurisdictions have held defamation by implication is not recognizable as a viable cause of action when the statements at issue concern public figures or matters of public concern. And then they cite a couple cases. Defamation by implication or innuendo is actionable only if the statements regard a private individual and private affairs. Statement about a public figure that is true on its face cannot support a claim for defamation by implication. Those are Louisiana cases. This is a Rhode Island case, finding that plaintiff as a police officer, as a public figure, is not entitled to recover on that portion of his claim alleging defamation by implication. This is a New Mexico case. The factual statements are true, and therefore the implication of misrepresentation cannot constitutionally serve as the predicate for defamation. Let's see. This is a Colorado case. The trial court did not err in concluding that as a matter of law, if the allegedly libelous statements are true, there can be no libel by innuendo of a public figure. We here adopt the view that there is no libel by innuendo of a public figure where the challenged communication is true. Where is that case from? Second District. And then another one in Louisiana. A lot of these in Louisiana. Louisiana is like no defamation by innuendo. Those are a lot of Louisiana cases. Other courts permit actions for defamation by implication of a public figure only when the inference arises from the omission of material facts in the challenged communication. And then we've got cases from Connecticut, I don't know what jurisdiction that is. Let's see. Similarly, courts that permit public figures to recover. This would have all been a matter of law to be decided. Like, why wasn't all of this decided? Why wasn't this all decided before? Not to mention, Depp is going to come back and argue, but the jury found that she was lying about all of it, so it's not true. Though I see the argument for the statements being true on their face, except for the headline. Like arguing, I became a public figure representing domestic abuse I can see the argument that it's true on its face. I don't think it'll stick. But the legal arguments, like as a matter of law, should have all been done before, and they were overruled. So they go through the different rationales for why this should be considered. I'm sure they'll bring this up on their appeal. I'm sure they're bringing up this argument now to get the court's ruling on it and bring up the appeal. I'm sure that's why they want to get Judge A's ruling down on paper, and getting Judge A's ruling down on paper will allow them to appeal on this issue, but they only have 30 days to file their appeal, and that's 30 days from June 24th. So they're going to have to appeal it probably before this is dealt with. So let's see. They say in trial, Mr. Depp did not present evidence that the statements at issue were untrue on their face. Didn't he though? But didn't he though? He proceeded exclusively on a theory of defamation by implication. He also did not attempt to prove the alleged implication arose from the juxtaposition of facts or an omission of material facts in the op-ed. There is no dispute that Mr. Depp is a public figure. He has expressing admitted. I find Grammarly to be very helpful if there is not someone rereading this. I still make typos. It happens. But some of these are just getting hard. There is no dispute that Mr. Depp is a public figure. He has expressing admitted he was a public figure, footnote 5, see Memorandum of Law, and tacitly conceded this point by tendering jury instructions that require him to prove actual malice. Well, yes, we know that. We're not arguing he's not a public figure. Moreover, this court actually ruled about that. Moreover, this court has already ruled that the op-ed addressed matters of public concern. The court did rule that. Even though Johnny Depp argued against it, he lost that ruling. Accordingly, Mr. Depp failed to prove defamation, and the jury's verdict should be set aside. No, what? How did we get there? Like, that was a leap. Moreover, this court already ruled that the op-ed addressed matters of public concern. They cited case law and then went to, accordingly, Mr. Depp failed to prove defamation, and the jury's verdict should be set aside. The jury's finding of defamation by implication with respect to the op-ed headline statement is contrary to the law and unsupported by the facts. The jury's verdict with respect to the headline should be set aside because under the applicable law and facts, misheard neither A, initially made or published, nor B, republished through a tweet the headline statement. That's just not right. That's just not right, though. That's just not right. That's just not accurate. Okay. It was a quote tweet. There is no support for the conclusion that Miss Heard initially made or published the headline. The newspaper added the headline, and Miss Heard played no role in authoring or publication of the headline statement. No. That's why there's jury instructions on republication. The jury found that there was republication. There's republication. You cannot change the facts this much in emotion. I think that this goes beyond zealous advocacy at this point. And I don't think that's going to be well taken by the judge at all. There was no support for the conclusion that Miss Heard initially made or published the headline. The newspaper added the headline, and Miss Heard played no role in authoring or publication of the headline statement, except for the republication that you're fucking ignoring. There is no evidence that Miss Heard ever made the headline statement as required for defamation by implication. All right, let's read footnote 6. Maybe a good footnote will make us feel better. Defamation by implication requires the following elements for each statement. 1, that the defendant made the statements alleged in the complaint. 2, that the statements, even if facially true, were designed and intended by the defendants to imply defamatory implications. 3, that in the light of the circumstances prevailing at the time they were made, the statements conveyed that defamatory implication to those who heard them, and 4, the plaintiff suffered harm as a result. I don't feel any better. There is no evidence that Ms. Heard ever made the headline statement as required for defamation by implication. The newspaper added the headline. Prove it. The undisputed evidence established that Ms. Heard never wrote the headline. The newspaper added it without any involvement from Ms. Heard. Republication. Ms. Heard played no role at all with respect to the headline. In fact, Ms. Heard never even became aware of the headline until Mr. Depp filed the lawsuit against her. Don't lie, Umbridge. She retweeted it with the headline being the most prominent thing. She didn't even know what the headline said. She said that she framed it. To be fair, she said she framed the print version. Ms. Heard testified she did not even notice it. The jury didn't believe her testimony. Ms. Heard testified she did not even notice it. In fact, there was a completely different headline in the paper edition, which version Ms. Heard had framed. Mr. Depp made no attempt to challenge any of this testimony. No reasonable jury could conclude that Ms. Heard made the headline statement given the evidence. The reasonable jury found that she republished it. Similarly, no reasonable jury could conclude that Ms. Heard published the headline. Republish is the word we're looking for. To prove publication, it's generally sufficient to show that when the defendant addressed the defamatory words to the plaintiff, another person was present. Here, Ms. Heard never addressed the headline to the plaintiff. She never wrote or conveyed the headline message. False, she conveyed it to a third party. This is splitting hairs in the worst way. I need the tweet. I need the tweet. I need the tweet. I just need the tweet. This is the tweet that has the headline below it. Today I published this op-ed. Today I published this op-ed in the Washington Post about the women who are channeling their rage about violence and inequality, into political strength, despite the price of coming forward. From college campuses to Congress, we're balancing the scales. And then under that, it has the op-ed with the headline. Oh, where's my second part of my tweet? Oh, I don't see my second part of my screenshot. I'll have to go find it. The second part of the screenshot has the statement below it. Okay. Just today I published. Those are the words. Today I published. Ms. Heard's tweet linking the quote tweeting. Linking the newspaper article does not constitute republication under the law. The judge already overruled this argument. This argument's already been overruled. This has already failed. Tweeting a link does not constitute republication, even if the tweet includes a mere reference to the article. The judge has already ruled on this. Republication requires editing and retransmitting the defamatory material or redistributing the material with the goal of reaching a new audience. Oh, isn't that what happened, though? Redistributing the material with the goal of reaching a new audience, her Twitter audience. But don't believe the tweet, y'all. Believe the motion. Although Ms. Heard's tweet called attention to the article and indicated she was the author, the tweet did not edit or add content to the article in a manner sufficient to overcome the single publication rule. The judge ruled against that. And we're not going to go through the rest of the argument on the case law. The judge has already ruled as a matter of law on that. Moreover, there is no evidence reasonably supporting a finding that Ms. Heard republished the headline by tweeting a link to the global newspaper article. Ms. Heard had no control over whether her link to the newspaper article included the article's headline. Actually, when you go to retweet something, you could not retweet the article and just put in the link and not populate the preview. And then it would just be the link and not populating the preview. So, Jordan, I'm going to look at this real quick. I don't think I can. Miguelina, can you grab this so I can put the link in and take a look? Because I can't pull the link from Jordan. If you don't mind throwing it in our chat so I can grab it. Because then I would have to find the tweet. But Yeah, it's just, you can put just the link and take out the pre-populated article. Okay, let's keep going. We'll take a look at that in a minute. Let's see. Mr. Depp did not represent evidence of actual malice. All right, before we move on, I'm going to try to pull up this tweet real quick because I want to take a look. Thank you, Jordan. Let's see. Oh, yeah, it doesn't look like a quote tweet. Jordan, coming in. It doesn't look like a quote tweet because it doesn't have, it's an embedded tweet. So look, today I published this. I'm going to screenshot this too. It's just embedded. All right, now I've got the whole thing. That's so much better. Today I published this op-ed in the Washington Post about the women who are channeling their rage about violence. And see, the use of the word violence here mirrors the headline here. But when you want to share an article, like if I wanted to tweet this article, I could grab the article link, go to Twitter, go to tweet, put the link, and then I can get rid of that. So yes, here it says that I don't know what this is called. The data here after Washington Post opinions, I've seen how institutions protect men accused of abuse. Here's what we can do. That doesn't have the headline. You can get rid of it. You don't have to, I don't know what just happened there. You don't have to tweet what it populates. You have the choice to tweet this or not tweet this. And if she hadn't tweeted that, it wouldn't have been a republication because this is different. The slug at the end of this is different. So this doesn't look like, because when I go to quote tweet, like if I went to quote tweet this, can I even quote tweet it? If I want to quote tweet this, it shows up as a separate tweet. And then I would make a comment, likely snarky. That says sharky. And then I would say shit. So with this, it doesn't look, you're right. Jordan, you're right. Not a quote tweet. She embedded the link in a tweet. Ha. So it's a tweet, not a quote tweet. It's an embedded tweet. It probably is irrelevant, but I don't know. Was this feature available back then is the question, but you've been able to remove from my remembering, and I did not use Twitter heavily in the late 2000s. So I don't know, but it's still not a quote tweet. It still is embedded. So not that it matters for this argument, but it matters for the law nerds because now we know. See, not even a quote tweet. There we go. Yeah, the today I published is the thing. The today I published is the thing. Could she have edited it since then? No. You cannot. This is the one argument for not being able to edit the Twitters. This is the one argument for not being able to edit the Twitters. You cannot go back and edit them. You can delete them or not, but you can't go back and edit them. So anyway, to tweet or not to tweet, let's get to the actual malice of it all. Mr. Depp did not present evidence of actual malice. We've already gone through the definition of actual malice. A public figure may not recover damage for defamation for a defamatory falsehood without clear and convincing proof that the false statement was made with actual malice. Did we see clear and convincing proof? Did we see clear and convincing proof? To establish actual malice, the plaintiff must demonstrate the defendant realized that this statement was false or that he subjectively entertained a serious doubt about the truth of the statement. The courts have a constitutional duty to exercise independent judgment and determine whether the record establishes actual malice with convincing clarity. Importantly, and then they go through more case law. They say, conversely, a jury's finding that the plaintiff's testimony is credible does not establish actual malice. In this case, proving actual malice required showing that at the time of the op-ed was published, Miss Heard did not believe she was abused or that she entertained serious doubt about whether she was abused. They found she was not abused. Furthermore, because actual malice is a subjective standard, whether Miss Heard believes she was abused must be judged by her definition of abuse. Miss Heard testified unequivocally that Mr. Depp abused her physically, emotionally, and psychologically. Well, and sexually. Mr. Depp presented no evidence that Miss Heard did not believe abuse can be physical, emotional, or psychological. No, that she didn't believe that she was abused. Oh boy. Ample undisputed evidence supports Miss Heard's belief that Mr. Depp abused her. That's not what they argued, though. They never once argued Miss Heard believes she was abused. Never once. They said she was. They didn't talk about her belief. They said this is what happened. They are trying to undo the way they did this trial, and it's not going to work. They didn't argue that. I think Rottenborn wanted to. I think this is the way Rottenborn wanted to do this trial. She believed it, whether you believe her or not. I think that's what Rottenborn wanted. That's not what Amber Heard testified to. These are different things, and these distinctions matter for this motion. Ugh. Ample undisputed evidence supports Miss Heard's belief that Johnny Depp abused, or that JD abused her. For example, Mr. Depp repeatedly asked Miss Heard to cut him with a knife and threatened to cut himself in her presence when she refused to comply. Miss Heard implored Mr. Depp not to cut himself in this recording. That's what they led with. That's what they led with. Mr. Depp intimidated Miss Heard by kicking cabinets and doors, screaming obscenities, and smashing glasses. He also destroyed property in her presence on other occasions. While fighting with Miss Heard, Mr. Depp pushed over racks of clothes and shoes in her closet. Mr. Depp forbid Miss Heard from acting in movies and having meetings. Mr. Depp texted Miss Heard, I have other uses for you. The fuck? Fuck you. Stop. Fuck you. Fuck you. Stop trying to make this a serious text. Y'all, I can't with this. It's so fucking disingenuous. I cannot. Mr. Depp texted Mrs. Heard, I have other uses for your throat which do not include injury. Stop with the sexting. Stop it. That's not a literal text. You know it's not a literal text. Everyone knows it's not a literal text. Stop it. Elaine, they're talking about blowjobs. Rottenborn, they are talking about blowjobs. They are not taught. This is where you lose everybody. There are arguments to be made. There are arguments to be made that some of the texts were horrific, were abusive. There are arguments to be made for psychological abuse here. Those aren't the arguments you made. The jury does not believe Amber Heard. Her testimony was about horrific levels of physical violence against her. These things got overshadowed by her testimony. Her testimony overshadowed all of this. So whether there was or was not psychological abuse, by the end of her testimony, the jury heard all of the evidence of physical abuse and did not believe her. Okay. Mr. Depp texted Miss Heard, I have other uses for your throat which do not include injury. Can you read it again? No. Mr. Depp repeatedly accused Miss Heard of infidelity and promiscuity and exhibited jealous and aggressive behavior, including the following. Is the video listed here with her changing the locks and having somebody else come up to her apartment? Is James Franco listed here? Using paint and his own blood, Mr. Depp wrote Miss Heard a, quote, reminder on a mirror in the house where they stayed in Australia, stating starring Billy Bob and Easy Amber. He left her this reminder directly after she filmed a movie with Billy Bob Thornton. Mr. Depp, are any of you persuaded? Are any of you persuaded by any of this? What I'm not seeing in these examples, and maybe we'll get to them later, what I'm not seeing in these examples are all of her items of testimony about physical and sexual abuse. I'm not seeing any of that. Why are we now defaulting down to he called her Easy Amber on a mirror? Why is that where this motion is at right now? And trying to make sex literal. Mr. Depp accused Miss Heard of having affairs with her co-stars. Mr. Depp's testimony that an argument was about his suspicion that Miss Heard was having an affair with actor James Franco. Well, I mean, there was video. After Mr. Depp told Miss Heard, I become irrational when you're doing movies. I become jealous and fucking crazy, weird, and we fight a lot more. Okay, and Mr. Depp physically intervened when he viewed someone as very affectionate toward Miss Heard. He testified that in order to protect Miss Heard's honor, I removed Kelly Sue's hand from Miss Heard's body, and I told her, do not do that. First of all, this is my girl. Second of all, it's rude and aggressive. And that's the Hicksville trailer park incident. T question, not the question. T question. T question is whether. T question to be or not to T. That is T question. T question is not whether T jury rejected that the what. I've lost myself in this sentence because I can't. I've lost myself because I can't. The question is not whether the jury rejected that the above conducted. The question is not whether the jury rejected that the above conduct constitutes abuse as an objective matter. The question is subjective. It is whether Mr. Depp proved that these events did not cause Miss Heard to believe that she was abused. Mr. Depp presented no evidence that Miss Heard seriously doubted that she was abused and thus failed to prove actual malice. So that's their argument. That's their argument. Their argument is that Johnny Depp never proved that she didn't believe it. Okay. That's not what anybody argued to the jury, though. And I think it's too late for these arguments. I think the shit's already out of the horse on all of these. Moreover, while domestic violence is not limited to physical violence, undisputed evidence also established Mr. Depp participated in physical fights with Miss Heard and used force. For example, Mr. Depp admitted in the recording that he, quote, I headbutted you in the fucking forehead. That doesn't break a nose. This is taking stuff well out of the context that the jury had, though. Because the jury also had... You guys watched the trial. This takes things out of the context that the jury had. While Mr. Depp testified that he did not intentionally headbutt Miss Heard, it does not follow that Miss Heard could not have concluded he intentionally headbutted her. She could have believed that Mr. Depp headbutting her was abusive, regardless of whether it was intentional. In other words, Mr. Depp presented no evidence that Miss Heard did not believe that his headbutt was physically abusive. In another recording, Mr. Depp stated, I left last night, honestly, I swear to you, because I just couldn't take the idea of more physicality, more physical abuse on each other. Okay. They are trying to make fetch happen, and it's just not going to happen on this. This recording shows at a minimum that Mr. Depp believes the parties' conduct could be interpreted as physical abuse of each other. I think that's reading into it exhaustively. Or that he believes Miss Heard views their conduct as physical abuse of each other. Either conclusion supports Miss Heard's belief that Mr. Depp physically abused her and that Mr. Depp adduced no evidence to the contrary. She didn't say she believed she was abused. She said she was abused. And I think this is reading way too much into actual malice. Because Mr. Depp presented no evidence that Ms. Heard did not believe he abused her physically, emotionally, and psychologically, he failed to prove actual malice, and the verdict must be set aside no. Mr. Depp did not present sufficient evidence to support a finding of defamation by innuendo. We've talked about this above. This should have gone with the section up above. This is just me being picky. But if you're talking about, I'm annoyed. If you're talking about defamation by implication, put the defamation by innuendo next to the defamation by implication and argue it together. They're not that separate. It's the same. When a plaintiff claims he was defamed by statements that are literally true because of a false implication arising from them, the implication must reasonably be drawn from the words actually used. They already argued this. No evidence surrounding the op-ed's publication would reasonably cause a reader to believe the title of the online edition is about Mr. Depp. They didn't argue this, and I thought they should have. They should have argued this much, much more. But once Amber Heard argued about what happened in Australia, Amber Heard told the jury through her own testimony that the headline was about Johnny Depp. So she said that, she did that with her testimony. If she had never brought up, ever brought up anything regarding sexual violence, they could have made this argument. They made this argument very briefly and very quickly and moved on. I thought it was a good argument about the headline. I think they could have argued it more, but after her testimony, they couldn't, because her testimony said, but this was true. And therefore the headline's true. I need more water. Let's see. They're re-quoting the same. Oh, that's because I moved up. No evidence surrounding the op-ed's publication would reasonably cause a reader to believe the title of the online edition is about Mr. Depp. Let's see. During opening statements, counsel for Mr. Depp forecasted with respect to the title, he would present no evidence of circumstances surrounding the publication of the op-ed that would suggest the title was about Mr. Depp. Counsel, have we forgotten that what's said in opening statements is not evidence? Because in opening statements, let's talk about what you talked about in opening statements, Elaine. Fecal phobia. And the fact that I need one now. I'm going to have to go find one. That the Milani pallet wheel was exactly what Amber Heard carried every day of her relationship. Let's talk about the promises you made in opening statements. Opening statements are not evidence. After this lawsuit was filed, Ms. Heard started making up more and more alleged incidents of abuse. And if you'll recall, ladies and gentlemen, the headline of the op-ed references sexual violence, but Ms. Heard had never made that accusation against Mr. Depp. It was part of her allegations of abuse. So what? It was never part of her allegations of abuse. So what changed? What changed between 2016 and 2018? We submit to you, and the evidence will show, when she realized the seriousness of what she had alleged, she panicked, and so she alleged sexual assault. So they're saying she did allege it, but she didn't allege it before. Brr. In other words, Mr. Depp's theory was that the allegations of sexual assault made after the op-ed's publication and after, well, no, that's what they said in opening. After the commencement of the instant action caused readers to understand the title was about Mr. Depp. This theory finds no support in any authority and is contrary to Virginia law, which requires plaintiff to prove the circumstances surrounding a statement's publication caused it to impart a defamatory implication. Consistent with counsel's opening statements at trial, Mr. Depp presented no evidence that prior to or shortly after the op-ed's publication, Ms. Heard accused him of sexual abuse. But she did in the UK. I need to look at the timing of that because those allegations came up in the UK. Ms. Heard accused him of sexual, The only evidence of prior allegations of sexual abuse was Heard's testimony in the UK, which she was provided with confidentiality when testifying about incidents of sexual abuse. She also testified that at the time the op-ed was published, she had never publicly accused Mr. Depp of sexual violence. But it doesn't stop them from believing she was talking about Mr. Depp after she testified that the op-ed was about Mr. Depp. And after she testified that he did those things. So I think they based this on her testimony. Not only was Ms. Heard's testimony about sexual abuse in the United Kingdom confidential, no evidence established it was made around the time of the op-ed. No evidence established it was made around the time the op-ed was published. As such, Mr. Depp failed to present evidence of circumstances surrounding the publication. Further, nothing in the op-ed suggests the title is about Mr. Depp. The title states Ms. Heard spoke up against sexual violence, which does not suggest she spoke up about violence by a particular person as opposed to violence in general. It's a fair argument, but the jury didn't believe the argument after she testified that this is why she wrote the op-ed, because of him. So I think if they had tried their case differently, this argument was a winner. I honestly believe that coming into this case, that if they had not brought up, if she had not talked about the violence that she testified to in Australia with a bottle and at Hicksville and elsewhere, that this would have been much harder. But once she testified that all those things happened to her, the jury's like, well, she's saying these things all happened to her before she wrote the op-ed. And then she said, this is why I wrote the op-ed about him. I think this argument loses. I think this argument could have won had they tried the case differently. But they didn't. And so they didn't. Nothing in the op-ed title suggests it's about Mr. Depp. He presented no evidence of extrinsic circumstances surrounding its publication could cause the op-ed viewer to be viewed about him. He failed to prove through innuendo that the title imparts a defamatory implication about him. Footnote 8. For the same reasons, especially Ms. Heard's testimony that she has never spoken publicly about sexual abuse, Mr. Depp failed to prove that Ms. Heard designed and intended for the publication to convey a defamatory implication. Testimony of the ACLU kind of did that. No evidence established contemporaneous facts surrounding the publication of the op-ed that would reasonably cause a reader to understand any of the statements as conveying defamatory implication about Mr. Depp. I feel like we've already gone through this. At trial, Mr. Depp's theory of defamation was that the op-ed implied Mr. Depp abused Ms. Heard. Yep. Mr. Depp maintained that this implication arose from the op-ed because on May 27, 2016, she obtained a DVTRO against him. Counsel for Mr. Depp noting in opening statements that Ms. Heard obtained a restraining order against Mr. Depp. Counsel for Mr. Depp stating in closing arguments, we've already heard that. In sum, Mr. Depp argued that circumstances 2.5 years before the op-ed's publication in December caused it to be defamatory. No court in Virginia, however, has ever permitted circumstances so distant from a publication to serve as innuendo. But she gave the timing. But she said, if she hadn't said 2 years, then shit from 2 years ago wouldn't have mattered. But she said 2 years ago. So that cites the reader back to things that happened 2 years ago. If it didn't say 2 years ago, then it doesn't matter. The response to this is going to be interesting. All right, where did we go? When, quote, the publication on its face does not show that it applies to the plaintiff, the publication is not actionable. But they found that it did here. Unless the allegations and supporting contemporaneous facts connect the defamatory words to the plaintiff. The contemporaneous facts being 2 years ago. Statements or publications by the same defendant regarding one specific subject or event made over a relatively short period of time, some of which clearly identify the plaintiff and others which do not, may be considered together for the purpose of establishing that the plaintiff was the person of or concerning whom the alleged defamatory statements were made. Explaining circumstances surrounding or circumstances prevailing at the time of the statements can result in a defamatory implication because Mr. Depp presented no evidence that within a relatively short period of time prior to or after the op-ed's publication, Ms. Heard asserted that he abused her. He failed to prove the innuendo. No. Mr. Depp cannot recover for statements Ms. Heard made during the judicial proceedings, and he failed to prove that any statements in the op-ed implies he abused Ms. Heard. What? As explained above, how long have we been streaming? Oh, forever. Oh, good. Sorry, y'all. We're keeping going. Thank you to the Mod Squad. As we move into this next part, over 3,000 of you watching across platforms. Will you do the YouTube things? Just like and subscribe and do the things. Thanks. Appreciate it. As explained above, Mr. Depp's theory of the case is that on May 27, 2016, Ms. Heard ruined his life by going to the courthouse and obtaining a temporary restraining order against him. We just filled that word in there in my brain. It is settled law in Virginia that words spoken or written in a judicial proceeding that are relevant to the that are relevant or pertinent to the matter under inquiry are absolutely privileged. Okay. So they're arguing that you can't have defamation born out of litigation, that litigation privilege essentially applies. We'll keep reading. But they're not saying that what she said in the DVTRO was the thing. It was the photographing at the courthouse is what they argued. Am I wrong? No, I'm not. That was rhetorical. I'm not wrong. They argued that being photographed at the courthouse and seeking the thing was the problem, not what was said in the thing. Mr. Depp has attempted to bootstrap statements that are protected by judicial immunity and time barred to the op-ed through a claim of defamation by implication. This attempt failed. It didn't fail. When did it fail? If it failed, you wouldn't be trying to set aside a judgment. This attempt failed because the implications that can be... This doesn't make sense. This attempt failed because only implications that can be, quote, reasonably drawn from the words actually used are actionable. The attempt... What? What failed? You're not trying to set aside the verdict because it failed. It didn't. That sentence makes no sense. Yeet that one too. Viewed in the light most favorable to Mr. Depp, the most the evidence could have shown is that if a reader was previously aware of the restraining order, then the statement 2 years ago, I became a public figure representing domestic abuse, could remind such a reader that Ms. Heard obtained a restraining order against Mr. Depp, but a reminder of statements made in a judicial proceeding does not amount to a republication of those statements. Oh, that is a big old Elastigirl reach there. In other words, reminding readers that Ms. Heard once obtained a TRO does not demonstrate that the statements in the op-ed amount to an implied assertion that Mr. Depp abused her. To hold otherwise would treat defamation by implication as a republication doctrine, improperly allow the To hold otherwise would treat defamation by implication as a republication doctrine, improperly allow the introduction of new matter, and would permit recovery for the innuendo itself. That sentence is so freaking awkward, I don't even know what they're trying to say. Mr. Depp did use innuendo to show that the op-ed conveys that he abused Ms. Heard. He has attempted to recover for the innuendo itself. Ms. Heard's testimony to obtain a restraining order in a judicial proceeding. It's gotten worse. Am I tired? This has gotten worse. This has gotten worse, right? Like the writing has gotten worse the longer we've gone. He has attempted to recover for the innuendo itself, Ms. Heard's testimony to obtain a restraining order in a judicial proceeding. No. They never talked about what she put in the restraining order. They talked about the photos and the headlines afterwards. Accordingly, the jury's verdict in favor of Mr. Depp should be set aside now. The court should conduct, here we go. Now we can swoop. Let's swoop. Fake juror. Fake juror. Let's see what they have to say about a fake juror. The court should conduct an investigation of juror number 15 and whether jury service was proper and due process was protected. Oh boy. Oh boy. The court should investigate whether juror 15 properly served on the jury. On the juror panel list sent to counsel before voir dire, the court noted that the individual who would later be designated juror 15 had a birth year of 1945. Juror 15, however, was clearly born later than 1945. How do you know? Was this juror wearing a mask? How did you determine the age of the juror? Like, we don't think so? Publicly available information. What publicly available information? What information? Publicly available information demonstrates that he appears to have been born in 1970. What information? This discrepancy raises the question of whether Juror 15 actually received a summons for jury duty and was properly vetted by the court to serve on the jury. The Virginia Code provides that at the time of assembly, for the purpose of jury selection, the identity of each member of the jury veneer shall be verified as provided in this section. Okay, there's rules. Thus, the court clerk's office had a statutory obligation to verify the identity of Juror 15. But because Juror 15 was not born in 1945, it appears his identity could not have been verified through any of the means of identification the code provides. And it also raises questions about whether and how Juror 15 could have signed a statement affirming under penalty of perjury that he was the named juror if he was 25 years younger than the person the court recognized as Juror 15. How do you know any of this? I have so many questions. Although the Virginia Supreme Court has previously construed Virginia Code 8.1-353, requiring the jury panel be made available at least 48 hours before trial, to be directionary rather than mandatory. Do they mean discretionary? That doesn't say discretionary. That says directory. To be directory. What is happening? Has my brain stopped reading? That says directory, not discretionary. What? I can't. Look. They knew they wanted to make this motion. This is not a small law firm. Are there not paralegals? What is happening? Okay. The Virginia Supreme Court previously ruled that requiring the jury panel to be made available at least 48 hours before trial is a directory. It's directive rather than mandatory. It is observed that adherence to the provisions of the code, abide by the code, is required to the extent necessary to ensure due process. It therefore follows that adherence to the code is necessary to ensure due process, even though it is viewed as a directory. Fucking hell. Rather than mandatory statute. Ms. Heard recognizes that the code states that, quote, any error in the information shown on the jury panel shall not be grounds for mistrial or assignable as error on appeal. Wait, what? What? The code states that any error in the information shown on the jury panel shall not be grounds for mistrial or assignable as error on appeal. Then why are you trying to mistry it on that grounds? Wait, where does it say that? Does it say that in here? Did I miss it? It doesn't say that in there. Okay, but it says it down here. Wait, there's more of this footnote. Ms. Heard recognizes that the code states, quote, any error in the information shown on, and then they edited something out, ... the jury panel shall not be grounds for a mistrial or assignable as error on appeal, and that the parties in the case shall be responsible for verifying the accuracy of such information. The code says that you're responsible. The code says it's on you. Now we're going to code red. Now we're motion granted for code red. WTF. It says you can't do it, and they're still trying to make fetch happen even though they can't do it. Y'all, we're going to go to code red. So for those of you that are new, code red does flash. If you are flashy thing sensitive, the flashes will stop after the music stops. 3, 2, 1. It says in the code that you can't do what the fuck she's trying to do. The parties are responsible for verifying the accuracy of such information. The parties, you're the party. You're the party. But the apparent error in the jury information form relating to Juror 15 is not the basis for Ms. Heard's concerns. It's not. They're trying to distinguish this. Okay, lay it on me. I'd love to hear it. How do we get there then? It is the potential that Juror 15 was not, in fact, the same individual that the court assigned as Juror 15 and or was not verified by the clerk's office as required by Virginia Code. This would warrant setting aside the verdict and ordering a new trial. Fake juror. Fake juror. They're alleging that there is a fake juror. That someone else slid in and was planted. Not that they failed to verify, but that this was a fake juror. They got to stick to the code, though. To the extent, I rock the mic like a mandel, light up the stage and make you jump like a candle. Sorry. To the extent that the individual who served as Juror 15 was not, in fact, the same individual on the veneer, or that the court clerk's office did not verify his identity, Ms. Heard's due process was compromised. The Virginia Code does not contemplate juror service by someone not on the veneer for good reason. If they showed up, they were in the veneer. In any case, but especially a high-profile case such as this one, it is critical to ensure no person who is not on the veneer is able to serve on the jury, whether by inadvertence or intention. Here, the facts show that Juror 15 was decades younger than the individual on the jury panel list. How do you know? I've got questions. Raising questions as to whether they are the same or different people. Ms. Heard therefore requests that the court investigate whether Juror 15 was properly part of the veneer and whether prior to jury service, Juror 15 verified his information in the manner prescribed by Virginia Code. Ms. Heard further requests that this court take appropriate action based upon the results of the investigation, including, if appropriate, ordering a new trial. If they did not get a new trial on the Juror 50 issue in the Maxwell case, I can't see it happening here because they were still able to question this juror. I can't wait to see the response. Conclusion, for all the reasons said above and for the reasons set forth on the record and other shit, Ms. Heard respectfully requests that the court set aside the jury verdict in favor of Mr. Depp and against Ms. Heard in its entirety, dismiss the complaint, or in the alternative, order a new trial. Ms. Heard further requests this court to investigate potential improper juror service and take appropriate action. Oh, shit. And that is the end. Oh, we've reached the end. Sweet summer children, all 53 pages. Damn, fake juror. Fake juror. We've got to get to questions. I'm going to give you my thoughts, and then we're going to get to questions. I think some of the issues they're preserving for appeal. What issue do I think is interesting for appeal on this? The question of defamation by implication with regard to a public figure. If that truly has not been vetted in Virginia, then there is an interest in the appeal court taking it up. Does it mean that they win or lose? No. But I could see that going up on appeal. That narrow question of defamation by implication with regard to a public figure. There are rulings on the court that they found that this was a public matter because of the way the op-ed was written. Johnny Depp argued it wasn't a public matter, that it was a private matter. But that's why this is coming up. I think that's why they were fighting over the public matter. I'm going to have to go back and look because now I'm very, very curious about all the fighting over whether this op-ed was a public matter or private matter, because I think that was in context of whether this slap and anti-slap came in. And what they found at the end of the day was that Heard could not rely on anti-slap as a defense. Sorry, my chair. That Heard could not rely on anti-slap as a defense because this was an intentional tort with malice. So I think that is actually an area where the appeals court, if this is appealed on, might be interested. They still have to file an appeal. This is just a motion to set aside. We've gone through these in criminal cases a lot. We haven't gone through these in civil cases as much. They don't come up in every single case we cover, but they do come up. So this is a motion it's a motion for new trial, a motion for judgment notwithstanding a verdict, and a motion to set aside. It's kind of all of them wrapped into one. But they are going to say, look, this juror is fake. That needs to be investigated. I can't wait to see the response from Team Depp on that because we'll get more information on it. We'll see what I think the court is going to throw out the arguments about the damages award. I think the court is just going to I think the court's going to deny all of this. But I think that when we get to appeals, the narrow question of whether Virginia law supports defamation by implication is an interesting question. So I think all of this gets denied. I'm interested to see what the response is. I don't think the court's granting a new trial for anything. The court might look into the issue with Juror 15. I think they have to at this point. And hopefully we'll get more information on the reply from Team Depp. I'm frustrated because this was not even in the court record yet. So let me go ahead and share Courthouse News, because Courthouse News is where I pulled this from. I'm going to share the link to the article here, and then I'll put it in the description as well, because Courthouse News had this document. It's not yet on the public website. I don't know why. When will it show up on the public website? I don't know. So with that, those are my thoughts. That was an adventure. We all went on that adventure together. Let's get to questions. I have questions. You have questions. Emily, are you still super behind and need to record a podcast today? Yes. Are you streaming for 3 hours nonetheless? Yes. So this is from Courthouse News Service, and they linked, if you go to the 43-page memorandum, they have it linked and available, even though the public website did not yet have it up. So that's why I included that link. Oh, boy, oh, boy, oh, boy. Can Amber and her lawyers get in trouble with the judge for the things they've said about the jury and the system? I feel like Elaine is burning bridges here. What the fuck? If I were a juror, I'd be pissed. If I were a juror, I'd be pissed too. If I was a judge, I'd be annoyed. We've seen the judge kind of clap back. I've seen reports from different transcripts where we've seen the judge kind of clap back at Elaine. There is a time where zealous advocacy can go too far. Have I seen anything where I think the lawyer will get in trouble, like sanctioned? Probably not, but it depends on what you define in trouble. Do I think that the judge's opinion of the lawyers involved in this case might have changed based on things that have gone on? Yeah. And that's not good either. That is reputationally damaging. Elaine has not been ideal in the way that she's done things, in my opinion. So, Jen, I'm going to make a note of that so I can get to it. How do trademarks work? Are they region, country bound? Are they global? Do you have to apply for them? You have to apply for them. They are a very specific area of law. They are regional. You can apply for them globally. They are much more difficult to enforce in certain jurisdictions. So if you are trademarked in the US, it doesn't mean it's enforced in Canada. And we've covered some trademark disputes, especially with regard to Toblerone. There were a few others when we were talking about the Ringo case that were brought up in that case about international trademarks in candy and some other things where you do have to get certain trademarks elsewhere. And there are trademarks within the EU that are different than trademarks in, China, different than trademarks being, adhered to in Australia, different than Canada, different than the US. So to protect intellectual property worldwide is an undertaking and an extensive undertaking. Rolf said, inventor of the 25-cent photo booths might have a claim against all of them. I mean, I think it's a good argument. Modema Rose, I think I pronounced that wrong completely. Modema Rose. Hopefully I got that right. The artwork impression of the first one received permission from the photographer. Subsequent ones did not. That's the issue. So when we go through the backstory of the Prince case, we will get into the underlying and how we got here. Yes. Why is this not a contract case? Warhol was contracted for a single painting for Vanity Fair. He broke the contract and made extras that were then later sold to others. Because the photographer doesn't have rights to the contract and have rights in the contract. So that's how we ended up getting into this copyright issue. But we're going to have to do a deep dive. Louise said, you keep saying Emily, and I feel like you were calling me. That's my first name. Hello, Emily. When I talk to myself, sometimes I do talk to myself by name. Meowlet, I love your Evie profile picture. I'm 32 and got my ADHD diagnosis about a year and a half ago. I wanted to tell you you're a huge role model for me, and I want to thank you for showing everyone can reach their goals. Well, thank you. You and your hair are awesome, from a fellow Colorful Hair Tribe member. We love the colorful hair. It's so much fun. We can see how brown it has gotten again. We definitely need some more color. I just have not had time. Fanny in the UK means a woman's. I know what Fanny means in the UK. That's why I was laughing. I believe Australia also adheres to that. Would you do a collab with How to ADHD? I would absolutely do. I love How to ADHD. It would just have to fit our content. We need to do. I think How to ADHD is great. How to ADHD is great. I can't believe how much you've grown in a year. I can't either, Jacob. It's wild. Yet here we are. Can we file a class action lawsuit to bring an injunction against Amber Heard? You're the best, Emily. 5-minute meditations help. Milo's mom, thank you. I think to stop the madness, maybe. So Caitlin P said, I saw Trixie and Katya live in Australia last week. Just wanted to share the joy. That sounds like it was amazing. I'm sure it was lots of fun. Do you work close to John Hatami? Wait, did you work close to John Hatami? You and him are LADA legends. John Hatami and I were in the same training class. Though since I left the DA's office, we have not been in connection, but I know he is definitely fighting the fight with the LA DA's office right now. Fizzy water and a bit of juice. I love fizzy water and a bit of juice, but John Hatami and I were in training. I don't remember which assignment we worked together. We were in downtown when I was trying cases at the same time, but not assigned there at the same time. Our careers have definitely done this across the county. I am tech at a law firm. Definitely use the line, have you tried turning it off and on again? At least probably once an hour. My partner ended up with more than arthritis. I'm sorry. She loved listening to you with me. New spiky Lawnard Bucky says hi. Hello, Bucky. And I'm sorry for the loss of your partner. Losing a pet is so hard. I can't pronounce that word. Space Cadet, I'm studying thanatology, and I can say it has helped me and my understanding of the world around us. I don't even know what that area of study is. I don't want to make a joke about Thanos. It sounds fascinating. I want to know more. I have an extensive IT background, education, MBA, and experience, including keeping up with social media trends and data. How do I break into that field? Suggestions. Thank you. You're amazing. Terry, I would start networking with some lawyers and letting them know you're available. So I would start with networking. And letting lawyers know what you know, and you can start doing expert witness work and things like that. So I would, network. Got me a purple iridescent Starbucks cup this weekend after seeing the gifts you got from the Lawnards. Also, my nails are purple iridescent with cat eye. My nails need to be redone. Thankfully, from back here, it doesn't look so bad. But yes, this is super fun. And if you guys don't follow me on the Instagram, I did a little bit of a mail time. I do those over there. A dash of cinnamon and Coke will make everything better. I've never tried that. That sounds fascinating. The allegations about age made me mad. Some people just look young for their age. Maybe they simply look youthful for their age. Pure jealousy. It could also be a typo. We've seen enough typos in this motion to know that things can happen. And we don't have enough facts about the juror stuff to know literally anything. There are so many more facts needed. So I mentioned in Runkle, how can they say JD had no rep and then say his rep influenced jury social media? Elaine, pick one. Well, what she's arguing in the court of public opinion and what she's arguing in the court of law are different. So those aren't inconsistent arguments in court yet. Baxter said, can you all sign the UK petition? You don't have to be a UK resident. Fed up with them referring to the UK trial. I mean, they're going to keep doing it. Black Belt Barrister has it on his channel. Thank you. So I don't know if the petition, I need to look how the petition will help. I don't know what they can do with the UK trial. Seems like Amber has to keep this case going in hope of winning something because she can't afford to pay Elaine and Rottenborn. Rottenborn didn't really have anything to do with this last motion. This was all Elaine's firm. I think they brought Rottenborn in for trial. I think he's done. I don't think he's even on the signature page. Hold on. Let's pull this up real quick. Elaine, I'm sorry. I thought this was the UK and used the same strategy. What, if anything, can I do to get a do-over? Argue that the jurors are too young. Let's see. Let's go down to I'm pretty sure that this just has Elaine's firm on it. That's oh no, Rottenborn's still listed on it as counsel. Let's see. Did they list it on the bottom page as well? This one just lists Elaine, but this lists Rottenborn as well. So Rottenborn's firm is on there as well as Elaine's. That reads like Elaine. And if I'm Rottenborn, I'm like, next time I'm proofreading it before you put my name on shit. Wait, doesn't the defense select the jury? Both parties select the jury. So just generally, voir dire starts with gathering a panel of veneer, and those, in a high profile case, you'll get questionnaires that go out, and then you eliminate the people who are like, oh my God, I'm a JD stan, I can't be fair and impartial. And then you bring in the people to court that have been agreed upon, and then you question them. The court questions them, and the parties have a chance to question them. They're vetted. They don't just, and then you can select jurors or pass on jurors. They don't just magically appear and you have to deal with them. There's a whole process. So yes. And it's interesting that the law says you can't bring this motion. And Elaine's like, I know I can't, but also hear me out. The point of is not to win this. The point of this motion is to be reported on extensively with the framing they prefer. Hazel, I think so too. And they do a lot of stuff that seems to be for PR. It seems that what the media is focused on is this potential juror issue. I'm curious about it as well. I want to see what the response is because we need more information. There's not a lot of information from Elaine. I would think that Elaine is hurting her credibility with this nonsense. I mean, some of these arguments are a stretch, but a lot of lawyers are going to be like, you know, you do what you can for your client. And if this is what your client wants to do, you keep doing it. They cannot let the UK trial go. If Amber Heard can't afford the verdict or the bond, how is she going to pay for another trial? I don't know. That doesn't add up. If Amber Heard is really asking for a do-over, I don't think they're really going to get a do-over on any of this. This motion is just an example of gaslighting. I mean, it's reframing, isn't it? Can trials from other countries be brought into trials in the US? It depends. Also, New Lawnard here. I appreciate you. Thank you. It depends. And last week's podcast, I break down that a bit more with the comedy. Rottenborn used UK case over and over and over. They lost, and now they're trying a different approach. They are. It's not going to work. She needs to save money to pay JD. She's not going to do that. Tamara said, is there a way that the court judge something could just tell Amber Heard and company to hit the road and bar them from doing anything more? No, they have a right to appeal because this is getting ridiculous and desperate and just leaning towards insanity. It is a reach on a lot of it, but they have the right to appeal. This is some of these traditional motions that you get to set aside a verdict. I think there were some of these grounds they could have left out and some of them that are fair to preserve for appeal. The question like, hey, Virginia hasn't answered this question about defamation. Hey, we don't see this as republication. Some of those legal grounds, fair enough, but some of them are just, whoo, man. When you come to cases and they cite on high damages, teachers year versus salary year, 11,000 teachers got 100K in damages. That's 9 times if applied. Johnny Depp gets 100 million. I appreciate the math, Nicholas. Thank you. The judge must be seething about this right now or amused. Maybe Judge A is amused. This is the case. It's never going away. Holly Jane, thank you for the super chat. My 3 this is why I try not to stream for more than 3 hours because my brain starts to stop. My 3 kiddos enjoy Technoblade. He will be missed. Cancer is the worst. I lost many loved ones due to cancer, including my mom when she was 56. That's so young. Thankfully, I survived breast cancer at age 39. I'm so glad. I'm now 44 and so grateful to be here. Love you, Emily. Love you too, Holly Jane. Thank you for sharing. And for all of those struggling, a light of hope. Should read this on a whiskey night. I would not have gotten through it. I would not have gotten through this on a whiskey night. I would have given up with the fuckery somewhere in the middle. Patty Joe says, I wish BBB could chime in here. He said, I think there's a good possibility that the UK is perfectly able to be reversed. We'll see. I mean, Black Belt Barrister is a UK attorney. I am not. I saw them deny the appeals. I don't know what the next step is. Amber loves the judge. Judge superior to jury. Therefore, jury in one country is automatically better than jury. Judge in one country better than jury in another country. Well, that's not what's going to happen, but I appreciate that interpretation. John Oliver was sued in Virginia. I don't know what that's referencing to, Danny, but thank you. Question, what does first impression mean? Allie, I wanted to get back to that. It means that the courts haven't decided the issue yet. So the appellate court hasn't looked at it yet. There's no appellate court ruling on it to get to it. So they are looking at it anew, and they might take it up for that reason. Casual Fox said, is she really trying to tell the court that because JD didn't dig into the details that would go against his points of the case should be labeled as a mistrial? That was her job, wasn't it? Some of it is her job, and they're saying he didn't prove it, but the jury, I think there's enough evidence here for the jury to make the ruling that they made. Screaming with you will piss off Judge Penny. I think Judge Penny's going to be like, this is never going to end. Please tell me that this is all a dream and that this document doesn't exist. Lie to me, Emily. I'm begging you. I need to sleep tonight. I will not tell you sweet, sweet lies. Here's the thing. We get to know more information about this trial, every motion that's filed. We get to learn more about the court's rulings, about the things that happen behind the scenes, and about what the parties are thinking. So this is all more information. So let's see what the response is. More information. I don't know who Lionel Hootsami is. Hootsme? Hutsme? Might have been a better choice for Amber. I don't know who that is. Regardless, reckless disregard for the truth. There are two types of malice. It is a tale of two trials, the one that happened and the one in the mind of Elaine. Well, of Elaine and her client. Emily, I bought a cup of coffee from Stanley just like yours. Yay, thanks for the heads up on where to buy it. Your team was helpful. You're welcome, TJ. I'm so glad. It's as if Elaine did not attend this trial. Penny, that's what it feels like. John Oliver was sued in Virginia for defamation. Years ago, he won. He's a public figure. They're saying defamation by implication is a matter of first impression, that the appeals court hasn't dealt with it yet. So has Rottenborn totally jumped ship and lassoed two sea turtles to sail off to the horizon? I don't think he has lassoed two sea turtles with the hair from his back to sail off into the sunset, but it seemed that Elaine's firm was handling all the written motions, and that seems consistent. Will Judge A be dealing with this? Yes. Judge A will be dealing with this. Elaine gives me hope I can pass the bar exam. Don't lean on Elaine. Don't lean on Elaine. You can pass the bar exam. Look, if I can pass the bar exam, you can pass the bar exam. I'm not a good test taker. I'm trying to make sense. It looks like this should be an appeal and not a motion. This is going to probably be a bit of both. This is going to be their motion to set aside, and then they're probably going to have a lot of the same arguments in their motion for appeal. Christopher Melcher refuted first impression by Pendleton versus Newsom case. Also, Amber Heard's team made a mistake and focused on headbutt as clear non-malice. I haven't looked at what Christopher Melcher has had to say yet. If they cited the Newsom case, so if that is truly a case that addresses the same issue, then they've cited the same case that proves it's not a matter of first impression in the same article. But this was a first impression for me, so we did not research those cases. Thank you for your comments on this. Helps us, that those that aren't lawyers, and thanks to the people that helps keep the chat clean. Love from Norway. That is the Mod Squad. They do a great job. I love watching all your content. Thank you so much for your truthfulness and speaking on mental health. You're welcome. Depp team did not show in the trial that she did not believe she was abused, with Curry testifying about her HPD. Oh, Depp's team did show, with Curry talking about her HPD and attention-seeking exaggerated behavior. I don't know if they spelled it out so clearly, but I think there's evidence there for the jury to determine that. I thought the amount for JH was too low, or JD, I'm guessing. How the heck can these lawyers get away with this BS motion? Well, they'll get called on the carpet in the response, but they are framing it in the light most favorable to their client. Some of it misstates, though, it gets to be a bit much. I'm shook. I thought JD deserved more. Fair. JD lost more than $100 million by losing Disney employment. Oops, JD. I figured that damages amount equals I'm exceedingly unshooketh. Right. And I don't think it's going to shake the court either. I thought she tried to keep the jury identity. Now this attacking them. I listened to the calls. AH never said it. Where are the connections AH had, Judge? Are the connections, I don't know what connections, unless we're talking about the UK judge. Sorry. Rottenborn first brought op-eds from 2012 to 2018. Okay. It should be more than 15 mil. He had to spend more than that to get the actual truth out there. Should she have to pay all of his lawyer's fees for Virginia and UK? It was her lies that made it so. No, this judgment's all she gets, and this can go towards lawyer's fees and probably will if they ever recover it. But he lost in the UK, so no lawyer's fees for him there. Question, why ask for a new trial if what was actually done? Could Amber Heard even afford a new trial? Probably not. Seems contradictory to Elaine's statements on TV. It does. but they know that it's not going to get yeeted without a new. There's no way the judge is just going to throw it out and be like, you're done. None of this gets to this was so prejudicial, you don't get a new trial. I think they want a new trial so they can do it better and argue things differently. They're not going to get it. If she's allowed a retrial and is allowed to bring up the UK trial, JD should be allowed to bring up the dog incident. Oh, and the arrest for domestic violence and other things. I mean, it's not as if stuff was kept out from just Amber Heard's side. A bunch of stuff that was unflattering to Amber Heard was also kept out. Seriously, do you predict there will ever be an end to this? No. He might have settled for less if she had just been quiet. I can't figure out what she gained with her D-line interview or what she thought she would gain. I think the Dateline interview was to get the last word. I think he would have settled, but I don't think she ever would have stopped. And so his settlement wouldn't let him get the truth out. If they had settled and he had gotten a NDA, then all he could have sued her for was a breach of the NDA. All of this wouldn't have come in. I think this was the only way to get his story out there. Andrea Burkhart said it best, the jury's entitled to believe evidence that comes from the other side too, Elaine. Yep. And the jury clearly didn't believe Amber Heard's evidence. Question, would the fact that Amber Heard admitted it was about JD, doesn't it negate the argument that it didn't mention him by name? It does negate it, but they don't want to acknowledge that. They didn't say it anywhere in there. Before the trial, I was upset with just the op-ed title, AH the Martyr. I can't listen to EB opening statement. Elaine's opening statement was scattered. Oh, they've put the spaghetti everywhere. My first super chat ever. I love this stream. Respect. Thank you so much, Joe Choi. Why did Amber Heard feel compelled to give evidence of DA by JD if she wasn't referring to him in the op-ed? Susan, I think you mean essay. I agree with you because those letters are next to each other in the keyboard. I agree with you. And I think that hurt her case. I think if she had not given evidence, then they could have argued it's not about him. But they tried to argue, and Rottenborn tried to do this in closing. He tried to say, this isn't about him, but if it is about him, it's true. And that argument's not going to win for most jurors. Yama said, I will die on this hill, but Rottenborn was the best lawyer Amber Heard had on her side. Agree. I hope others can see that and continue to hire him. I think Rottenborn had a good legal strategy in his opening. If you go back and look at Rottenborn's opening, if they had tried that case, they had a much cleaner chance at winning, but they didn't. That's not the case they tried. The case they tried was Elaine's opening argument, and that's the problem. Rottenborn had a winning strategy. Elaine plus Amber Heard strategy. Keep throwing enough shit that eventually some might stick. It's not going to work in this one. I had 3 years of legal training to act as a legal assistant. I can't believe how much more I know than Elaine. Jerry, all of us, all of the chat. I'm not even surprised that Amber can't let this go. And just remember what Dr. Hughes told us all about surveillance behaviors. Hazel Angus, thank you. Yeah, Dr. Hughes said a lot. Gonna be a doctor soon. Congratulations. So her plan was to tell a jury in the colonies that a judge of the crown ruled for Amber Heard. Good strategy. That never backfires in the U.S. Josephine said, does this motion to set aside go to Judge Penny? Yes. The appeals court or the Virginia court? No. Judge Penny. Also high. It goes to Judge Penny. Judge Ascarati. Because when I say Judge Penny, then it makes me think of Brittany's judge, because Judge Penny there is the judge's last name and Judge Penny here is the judge's first name. So Judge A. This will go to Judge A. I don't know when it's on calendar. Why are there two firms representing Amber Heard? Is Rottenborn still involved? Rottenborn seems to still be involved at the trial court level. They will probably have different, I would imagine they would have different attorneys or different attorneys from the firms for the appellate level. Most attorneys do one or the other or are more inclined to do one or the other. Attorneys that tend to be really good at trial don't generally want to do appeals because appeals is a lot more written, where trial is much more on your feet kind of a skill. But I don't know, maybe Amber Heard's lawyers are appellate lawyers and that explains their trial behavior. All I see reading this is Veruca Salt stomping her feet, screaming, I want it now, which is kind of ironic. I mean, clearly the judge didn't include pirates or the award would have been higher. Clearly the jury didn't include pirates or the award would have been higher. I mean, who knows how they got to their number? They're allowed to determine it. What, if any, chance of success does this have? As a motion to set aside, I don't see any as a motion to set aside. I will be interested to see what they mirror on appeal, but I don't think any of this is going to get stuff set aside. I'm curious about what's going on with the juror. I want to see what the response or the reply says about that. But some of the other arguments are arguments they should have made in court. I don't think they're going to get set aside. I think there was enough evidence here to go to the jury, and nothing in the jury verdict is so outside the realm that a motion to set aside will be granted. They're rare that they get granted, especially once it gets past the point where you get that motion to strike after the evidence is in. This court said there's enough for a jury to find anything here. So arguing that there wasn't enough for the jury to find it is really duplicative of what they've already argued. At what point do Elaine and Rottenborn stop funding these legal motions? I have no idea what the agreements are for people to get paid. Lawyers generally don't work for free. Question, since this was televised, would the law teams go back and watch the trial and try to decipher it like play by play, trying to find faults like, or the opposing side? And then move to dismiss? I mean, I don't know how much they would have used that. I'm sure they would have used it some, but they might just be using the transcripts. I don't know. Kim said she gave more weight to the op-ed immediately posting and announcing she was an ACLU ambassador. The ACLU, bringing a national civil rights org, gives the op-ed and WAPO more believable weight than the other one. Yes. Did Rottenborn sign it? No. EDB quoting Dr. Seuss's life. Thank you. Does Judge A need to respond to this in detail? Doesn't it waste hours on end of the chief judge's time? Is that a good idea? Whether this motion is a good idea or not, the judge will respond. I think the judge will probably respond in writing, but we're definitely going to get a response from Depp first. I just don't know why we're not seeing it on the court's website yet. I've seen Elaine and Amber say they won the UK trial. They were not a party in the UK trial, so why is it so important to have the decision put in? That's why the decision's not put in. I talked about that in last week's podcast. That's why it's not put in. They weren't parties. Elaine could get a second time to ask a better question. I mean, no. KIU, aka Christine, I experienced the same with my dad, my dad did. He was all over the news and it was awful to be reminded about it every day. I lost my mom to suicide 5 years prior. I'm sorry for your loss, and I'm sorry for that. Having these kind of news swirls is not easy for kids. Serious question. How are they able to argue about how the jury awarded when it's not known? Is this a usual argument or Elaine specific? Well, you've seen from the case law, it's not unusual to argue that the award is outside of the evidence, and it can work if the award is so outside of the bounds of the evidence. I don't think that's the case here, but it can be the case, and it does happen that jury verdicts are reduced by the court. Do you think this is an attempt to unseal the jury? No, the lawyers know who the jurors are. They have that information. It's the media that can't get to them. No, I don't. And Amber Heard's team's the one that asked for the jury to be sealed. It's interesting that she keeps fighting over this when all she wanted to do was to be left alone. Yep. It's not going away. Thank you to the moderators. A huge thank you to the moderators. Rando from Iowa. How is this proper in any way? Elaine is basically waiting until after the trial's finished to say, whoops, you made a mistake. Guess we got to do it again. That's not improper, though. Some of these things are things that do get argued afterwards to set aside a verdict. Some of the arguments are just not well taken by me, but these are after trial motions that the losing side makes. Is Amber Heard, she was bested from Camille? I don't know. I don't understand. I'm sorry, Julie. Can we take a second to discuss the fact that they talk about excessive damages amount, but Amber Heard also got a sever amount and punitive? They didn't believe her. Yeah, I think we talked about it. Question, isn't it hypocrisy to say he had no reputation to destroy, but yet the media thing, and they've been claiming star power caused the verdict? It's hypocritical. They've been arguing one thing to the court of public opinion and one thing to the court of law, but they're not precluded because they're not arguing both things in the court of law. Do they not proofread the papers? It looks like they haven't. All of the motions are poorly written, shows lack of professionalism. It's hard to focus on reading the motion. They are not super well executed. So, will you be reading Britt's attorney's motion filed this weekend regarding Lou Taylor? Yes, I will. Brittany needs a whole day. I talked about that at the top of the stream. Amber Heard's fines $10 million excessive because she never made anywhere near that much. I I think they find it excessive because they're saying there was no basis in evidence, but the evidence showed that there was, I think they said upwards of 40 million that he lost was what his experts testified to. Elaine's trying to justify her $6 million fees, total fetch. Ask Team Amber Heard to leave JD and us alone too. I mean, we all should ask Amber Heard to leave us alone, but it's not going to happen. Objection, what the fuck? That's where we're at. If a jury believed the cops, then they had to find the statement by AW false because neither set of cops saw damages in the apartment. Simple logical reasoning. Oh, by Adam Waldman false. Yes. The cops said they never saw it. So yes, they find it false. I agree with you. I don't think it's inconsistent. Movie Smith and Monsters did a vid with new detailed info that May 21st was a hoax with in-depth time chart. That might be the case, but that's not what the jury had in front of them. So anything that's done outside of court doesn't change what the jury found. The jury evidence makes the evidence that came in at trial makes that verdict make sense for me. Judge Penny is so over this that Elaine asked her, how was your vacay away from this? She rolled her eyes. She's so done. She probably is done. John Oliver won a defamation case in Virginia years ago. Okay. Navy drill instructor here. Hello, token black hat. Hope all is well for you. Question: in the case of a retrial, would Johnny Depp's team be able to point out the differing testimonies of Amber Heard and her sister's accounts of the staircase incident? I think they pointed it out a little bit here, but yes, they can. I think that's a long way down the road, though, and I would not like to see it. I do not want to see a retrial on this. Just curious, but doesn't their argument mean that Johnny Depp could have the fault for the Waldman statement tossed out? Yeah, they're arguing the whole thing should be tossed out. They're arguing both sides should be tossed out. I watch for many reasons, but mostly to hear you say, Elaine! Elaine! Could lying and misrepresenting facts and emotion cause Judge A not to review all of it? No. Is it legit to misstate facts like that? It's not advisable. There's a difference between misstating and characterizing things. And there are some things in here that I think are misstatements, but there are some things in here that are creative characterizations. Judges see through that. Alf said, is it me or is 70% of this a repeat of the motion to strike? Yes, it is. Yes, it is. All right. So thank you, Jordan, for pointing out the tweet. The judge will probably deny all of this. I agree. Judge A, sanction EB, no. And this isn't an appeal yet. JD never had one scintilla of control over Amber Heard, not for one teeny little second. Question, did you ever get emotional in court as a prosecutor? Yes, which is where me apologizing for emotions comes in. I've told some of those stories in different content, in different contexts. But yes, there were times. There were times it was very hard. Now the text makes sense. Well, thank you, Chuckles. Hopefully Elaine watched. We've talked about the throat. I think she just told the truth about her relationship here. I don't know what part that was referring to. I wish I did. I was on a conference call, so I might have missed it. But the fact that Australia is looking to get Amber Heard for perjury mean anything with this appeal? No, it doesn't. JBM. Again, like the UK case, different systems. Do you think Elaine is used to winning by burning another in paperwork? I think Elaine is used to cases settling before trial. When were Waldman's comments, before or after the op-ed? After the op-ed. I really feel bad for Judge A for having to read this rubbish. I mean, and her judicial assistants. One injury event JD admitted to, headbutt, isn't here. The headbutt was mentioned in that. Did she use grammar check at all? I don't think so. Question, can Elaine clarify fecal phobia? She never brought it up again. Finally, they got there, but why not say that in court? I don't know. Josephine said, but I thought she said outright on the stand that she never claimed to be a victim. She did say that. Doesn't that kind of show she didn't believe she was abused? It's a fair argument. I think it's a really good argument. Disney Gal, I can say I believe that I'm a billionaire, but it doesn't make it true. T in Tennessee said, I bet she wouldn't let them use, she believed it because it might have conveyed she actually lied. I thought appeals were to present an error in law and not essentially printed retry it. This is not an appeal. This is a motion to set aside the judgment and the verdict. So this is a motion to set aside in the trial court. An appeal goes up to the appellate court. So this is still trial court motions. Amber and Elaine, Well, the jury didn't see things the way we want. We didn't lay them out. Fair. I'm at the gym since after the trial, my BF was all done with this at home. I heard page 12 of 58 and my legs just cried a little. I'm sorry if it's leg day. Never miss leg day. I can see your head starting to explode. Yep. Isn't the entire trial illogical? If the article wasn't about Johnny, why did she have to prove he abused her? It's unrelated to it. Isn't about him. Jenny, I agree with you. And that's the way they went. Motion to have Amber Heard's lawyers make a partial refund of the millions they charged. That's on her to do, or to file bankruptcy and not pay them. Ken said, I thought the ACLU stated the draft for the op-ed had Depp's name in it. They did. Amber also stated that it wasn't only about him, but the phenomenon as well in the industry at the time. She did. And they did. You're correct. Late to the party, have you seen Tug's video stating that Law and Crime found that Judge A gave advice to Elaine? No, I have not yet. Didn't Josh Drew testify they spoke to an attorney and publicist? Amber Heard, I think, also stated that she talked to an attorney. I mean, they did talk to them, but I think the rest of the statement did not. I think the police, the second round of police and the video showing that there was no wine spilt and all of that really killed that statement. They approved him, couldn't tell he was 50, not 75. I guess. Do you think they used public records and found the juror's son with this? I have no idea what they did. And I'm not going to speculate on it just because I truly have no idea what they're talking about. Didn't they go through the jury selection weeks before trial? Yes. Wouldn't they have saw that both Amber and Depp's attorney agreed on jurors? Yes, both attorneys agreed. They all agreed. This feels like when someone has to write a paper and they don't care about for class, and the longer it goes, the sloppier it gets because they just want it to be done. The word salad lack of continuity is pure Elaine. It was hard. It was not well laid out. Like, we get used to reading good motions, even though I disagree with a lot of the arguments like James Spears lawyers make, they're at least well laid out. I appreciate that even in the midst of your righteous rage, you never forget to warn about the flashes. Well, you're welcome, apple pie. Oh, they want the juror names to go after them direct. They knew what the jurors' names were, though. They had that information at the beginning. So, no. Does Amber Heard really don't have any other strategy but to bring up the UK case? Yes. Span said, how big of a deal is it that Elaine was forcibly removed by a judge from the Dynacorp case for instructing her employee to destroy evidence? I've not heard of any of that, Spans McNamara. I know she's supposed to be a highly respected lawyer, but she seems shady to me. I know nothing about the Dynacorp case, or Dynacorp case. I know nothing about that. So if anyone wants to email me about that, feel free. This whole motion seems like Elaine and Rottenborn wanted to put on, seems like the case Elaine and Rottenborn wanted to put on, but Amber got in their way. I think it's the case Rottenborn wanted to put on. Elaine's whole thing has been a word salad. Wait, wasn't Juror 15 the one claiming things on TikTok? I don't know. I thought the person claiming things on TikTok was not a juror. Okay, I'm going to try to get to a few quickly, and then I've got to go. Court TV said Judge A was snarky with Elaine. She want to set up a schedule for hearings on motions. That was at the day of the judgment. They were just on calendar for a judgment. I wouldn't be surprised if they were like, stop it. Name mix up father versus son. That's also possible, especially if they live at the same house and didn't put junior or senior on the thing. What could happen if Johnny Depp appeals? We're not there yet because we haven't seen an appeal. We saw their objections that I talked about in the last video where I covered this. I covered their objections. At least I have a reason to continue wearing my Johnny Depp is innocent t-shirt. I mean, for sure. Can Johnny Depp get a cease and desist against Amber Heard? Hasn't yet, but not with regard to court motions, only with regard to public statements. And I think an injunction would be better, but they haven't done either of those. So as we get to see per press and the whole shebang, are we not entertained? I mean, yikes. Amber Heard side sat on Juror 15 for 6 weeks, now an issue. Interesting, isn't it? I'm questioning Amber Heard's PR team and legal team. I've been questioning for the whole time. My name is Virginia. This case drives me nuts. I'm sorry, Ginger. Ginger, Virginia. This motion seems like a grasp. It is. Like Elaine at the podium saying, I'm trying. It kind of feels that way. Love you, Emily. Thank you for your coverage. Definitely make the foolery bearable. This one was hard. Petition to have the UK trial revisited without Johnny Depp's involvement. Petition is to have the UK trial revisited without Johnny Depp's involvement. I'm sure it is. I mean, I don't know if it can be. When I was a paralegal, the attorney wrote foul versus foul, and boy, did we get it for missing that mistake. And that's a very, very little one. Right? I'm still annoyed Elaine didn't fulfill her opening statement and promise to show us Amber Heard has fecal phobia. I'm still angry too, nor did we see the Picasso. Speaking of reputationally damaging, did you see Elaine's career being damaged after all of this? I don't know. I truly don't know. Will Amber Heard have to pay the judgment in order to file the appeal? The cutoff date is fast approaching. No, she would have to post it in a bond. She doesn't have to pay it to the other side. She has to bond it. Johnny Depp will appeal so Amber Heard won't take her $2 million. Meanwhile, he might post a $2 million bond just to appeal, just so he doesn't have to pay her. This is just a thanks. You're welcome. That document was painful. The tape where Amber dares Johnny Depp to tell the judge, jury, see who they believe is evidence she didn't believe she was abused, in my opinion. It enraged Bacon. It's a good argument. It's a good argument. There's a lot of arguments to be made. How do they expect to win on appeal or new trial if they keep throwing jury and judge under the bus? I don't think they care because it would be a new jury and a new judge. I don't think they care about burning it. At what point during the Depp Heard trial or before the trial did you come to the conclusion on your stance on who would win? Before the trial, just reading the allegations, I didn't think there was a way Johnny Depp would win. After Amber Heard's testimony, her own testimony is when my opinion started to shift. And then during the rest of Amber Heard's case in chief, my opinion started to shift that he could win the headline. I never got to the point that he was going to win all of the counts. I didn't think that at all. I was very surprised by that. And when you watch the verdict come in, you'll see that I'm surprised by that. I thought he had a chance to win on the headline, but not the others. I was wrong. The jury went with all of it. Oh, I'm still meaning to make a note of that. So let me get to a few more, and then we are going to wrap up at over 4 hours. Off topic, but one of the Chrisley prosecutors was my professor for criminal pretrial motions. That must have been fascinating. There are a lot of prosecutors that teach, which is fascinating. Where is it possible to hear stories of you in trial? They kind of get smattered throughout my content here, and oftentimes in our members only live streams as well. Did I not read somewhere that you and other law nerds are being issued cease and desist orders by Amber Heard and her girlfriend, her Acme lawyers? No, that hasn't happened. That would be such a like KJ callback moment to be like somebody on Twitter being like, you all must cease and desist. But no, you can't cease and desist someone from covering a news story, unfortunately for them. I hope you have good rest when the stream ends. I've got to record next week's podcast when the stream ends, because I didn't feel good over the weekend. I didn't do it. Could Juror 15 be a junior and summons was for a senior? Share, very, very possible. We'll just have to see what the answers are. That would be a weird circumstance, but it's possible. What is the time frame for the judge to reply? I mean, the judge has their own due time. I don't know what the timing is for motions to set aside. Normally you get like 20 days to reply, and then you get time to post. You get 20 days to object, and then you get time to reply. I don't know the exact timing in Virginia. Rob of Law and Lumber would know better than I would, but I think we'll probably have in that range, like 15 to 20 days for Depp's team to reply. They could do it sooner. Nina Land said, do you think she's trying to poke back at the juror that spoke out? I don't know. Maybe if that was the juror that spoke out. Do you think Amber Heard's team being genuine and all this post-trial stuff are attempting to muddy the water? I think they're making some of the motions so they don't get sued for not making the motions. And I think some of it's trying to make a PR statement. They've said a lot. Remember the UK case. Remember the UK case. Remember the UK case. They've said it so much. It's not legally relevant. And we talked about that last week. I love the let's throw poop at the wall and see what sticks from Amber Heard's lawyer. Mess. Do you think Johnny Depp's team will point out that the multitude of spelling and grammar errors in this? If they're being shady, maybe a little snark comment. Are they trying to do this to get the jurors to come out and talk? I don't know. I mean, there's nothing a juror can really say with this, truly. Question off topic, but will you do the case against Vince McMahon? Yes, I will. I just haven't had time because this case won't stop. And Britney Spears' case won't stop. There are so many motions in the Spears case. So because other stuff is popping off, it's hard to pull in something new. But I intend to. I'm just going to have to stream more often. Question, will a judge be required to respond to the appeal? This is not an appeal. This is a motion to set aside. Yes, the judge will have to make a ruling. Do you think she will investigate the fake juror issue? I think they'll absolutely pull up the registrars and look at what they need. What are the chances the jury issue will cause it to be thrown out? Very, very low. But we don't know what the full issues are yet. All we know is that they think that somebody's younger than they think they said they were. Like, we're not even there yet to really evaluate it. We need more. We need more. Can we even try what Elaine's claims anyway? I think Rob at Law and Lumber said defamation by implication is allowed in Virginia. That's not what they're saying. They're saying defamation by implication is not allowed for a public figure regarding a matter of public awareness or a matter of public concern. That's what they're saying. Wouldn't this be hard to retry since everyone has heard about it? Yes, I don't think we're there yet. Thanks, EDB and mods, for everything. Can we get daily EDB someday? I will talk to the team about it. It is very hard to prep and do a daily show without getting more team on board, but we will see. That'll be a decision I'll make after the summer, because I've got a lot of kid stuff that kind of pulls me out of the house. So prepping and doing a daily show takes a whole different level of effort. Does a motion to set aside give more time to appeal? Great question, M. No, it does not. You're killing me, Smalls. What email? Please explain. I said that I could be emailed. My email is publicly available in all of my things. It's Emily D. Baker at Semaphore. So that's there. So with that, you guys, I know there's lots more questions. I've got to go. Question, is there a point at which this shotgun approach may cross the line between zealous advocacy into bad faith? At this point, I don't think we're there yet. Team Depp keeps trying to argue it, and we see it get argued in last week's episode of The Emily Show. If you guys aren't listening to the podcast, The Emily Show is on your favorite podcast playing app. It's also here on YouTube. Last week, we get to the end because at the end of that motion, Team Depp did ask for sanctions, and the court said, you know, this is not a well-founded motion, but we're not sanctionable yet. So if you want a breakdown of when the court says this is not sanctionable yet, it's in last week's Emily Show. So last week's TES is available for you on your favorite podcasting app here on YouTube. Next week's will probably be late. Why? Because I haven't recorded it yet. So next week's will probably be late. If you are not doing the likey, subscribey things, do that. If you're replay crew and you've made it this far, love you and your dedication. Thank you, everyone who's live, for getting through this fuck balls long motion. I might have to try to clip this down into a quick bits because this one is a mess, and I think I could probably do it in like a 10-minute more succinct way. So we might have to do a quick bit on it as well, because this was a disaster of emotion. But it's interesting. There's some interesting bits to it. And with that, thank you. Thank you for being here. Thank you for being law nerds. I've told you where to go do the things. Our members only live stream. I need to check the calendar for when it's coming up, but that should be next week. So there's time to join over at Patreon, Law Nerds Unite, and here on the YouTube channel. So you can go do all the things that I'm going to tell you about right now. I will see you in the next one.
Connect with me everywhere. I'm at the Emily Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, LawNerdsUnite.com. Happy to have you. Support what we do here on the YouTube.